exact amount?
Yeah, it's more than 3 months, but it's not more than 6 months either. I did the best that I could under the circumstances. I was swamped with work.
All right, and is this a trend that you've had some difficulty with in the past?
No, not at all. Not at all.
Okay, thank you, CJ. I have my second question. We note, and I think it's very commendable, your experience moving from a court interpreter up to here, up to this particular moment in time, that you're also very involved in your community, in the tribal authority, but also in the church, which I think we all can understand. But I am interested whether you've had any cases before you that have caused some tension between some of your views that may arise from there, from the church and the tribal authority, and of course your role as judge. Specifically, whether you've had any matters before you relating to the LGBTQIA plus community, and how you've dealt with those in the past, or how you deal with them in the future. How do you resolve those tensions, but specifically related to the queer community?
To the queer community? No, I haven't had matters dealing with the queer community, as you say. But if I were to be confronted with a matter of that nature, I will deal with the matter on the facts.
All right, so it wouldn't be a matter of recusal?
No, not necessarily.
Thank you, CJ. I'm comfortable.
Commissioner Recuse.
Thank you, CJ. Good morning, Judge Chile.
Good morning, Commissioner.
When you outline your plan, I haven't heard you talking about the relationship between the staff and judges and other stakeholders. Can you speak on that? What the importance of a healthy relationship between staff on one hand and judges, as well as the relationship with other stakeholders, the profession, and
yes,
all the role players in the court, and how it is helpful.
It's very important, Commissioner Mchisi, to have a good working relationship with all the other role players, because otherwise than that, you won't be productive.
Yes. And then the second aspect, there is I just observed recently, most magistrates, they want to be judges. They want to act as judges. And that impact on the magistrate, that was on the work of the magistrate in district courts. There was an instance where in another court, a magistrate went to act. The accused was in custody, case postponed over a long period. How do you balance that? That is the need of integrating judges, magistrates to act in the High Court, still not affecting the delivery of service, of judicial service to the communities, which is called front of justice. That's one. On one hand, most practitioners in the private sector, in the private practice, they are reluctant to take acting appointment as judges because of underpayment of judges. In fact, there's simply no payment. As an acting judge, when you see, when you are acting there, you say the man that you are not too sure whether this is salary or maybe it's something coming from somewhere, that there's non-payment which is not attractive. How do we attract from private sector, from private practice, competent practitioners and who will be able to hit the ground? Balance with that with the magistrates who see ascendance to the bench as a promotion, then abandoning their own original work that they should do. How do you balance this? What can you say? In broad terms, I'm not asking for a specific answer, but just a problem I've observed, but I want your views.
Yes. With regards to the magistrates, that has to be cured. We have to find a way to cure that. With regards to counsel, I don't think I'll be in a position to deal with that sufficiently, because I do not have the funds to
Chief Justice, I'm just saying,
Yes.
would you agree with me that really in South Africa, judges are simply not properly paid? They are underpaid. At one stage, their
Yes.
payment was delayed for so many years,
Yes.
but they are underpaid. That's a fact. We accept that as a fact.
I don't know whether
I
I should-
know the challenge, you might not be ready to answer that question, but do you accept that judges in South Africa are underpaid?
Be very careful
don't-
how you answer that question, Judge
Sorry?
Celi. I'm cautioning you to be very careful how you
Yeah.
answer that question. You don't
Try-
want to upset your colleagues.
That's why I'm saying. That's why I'm saying is this question. If you have problems, you may not answer, but at the same time, I'm just saying you can answer. One way.
Yes, yeah.
You can agree with me. You can say, "Well, I have no comment." If you don't, I would accept and live with.
Can I defer to the CJ? Yes.
Commissioner Moiman?
Thank you, CJ. Greetings to yourself and the fellow commissioners. Greetings to you, Judge Stili.
Good evening. Good morning.
Just one clarification question from my side, emanating from the response that you gave with the interaction with from the JP side on your position as chair of the traditional council.
Yes.
Vis-a-vis also your position as judge, and now applying for the deputy president, DJP. The applicable legislative framework suggests that you may appoint your deputy, which obviously is discretionary, in consultation with the royal family, when you are elevated either to a higher position. Let's say you are elected as the chair of the provincial house. I guess because the two position has discussed implication also, that could be a consideration. What is the position in the province? Is it not something that can be dealt with differently? Not holding two positions of influence. That's clarity from my
I'm
side.
sorry, Commissioner. Can you repeat that?
I'm saying that the applicable framework in terms of the traditional leadership
Yes.
suggests that when you are as the chair of the traditional council, when you are elected to the chair of the provincial house or deputy, you may appoint a deputy. Now, in your situation as a judge,
Yes.
is it not advisable to appoint a deputy of the traditional council, having consulted with the royal family?
Oh, I see. I see.
Of course, probably maybe the policy consideration in KZN is different. So that is the clarity-seeking question that I wanted to get from you.
Well, I think perhaps that consultative process is important because as the in-course, you have duties that are assigned to you by the members of the community. I will agree with you that a consultative process is important.
So is it not advisable from your side to relinquish the chairperson of the traditional council and appoint a deputy so that you focus on your position as the deputy judge president when you are appointed?
Sorry, can you repeat that? I'm sorry.
Is it not advisable for you as a judge
I see.
to appoint a deputy chair of the traditional council in your position as
Oh,
a
in my
chair?
position, I see.
Because you are a judge, and I thought when you are a judge, you cannot hold two positions that has remunerative implications on the fiscus.
I am not receiving any remuneration for that. Firstly, I'm not receiving any remuneration for that. I mean, as the chairperson, I'm not receiving any remuneration. That is number one. Number two, I don't sit full time. We haven't sat in a very long time. We only sit if there are issues that we have to deal with. So there is no conflict at all.
You agree that the legislation says you may appoint a deputy. The legislative framework says you may appoint a deputy.
I may appoint a deputy in my place as a chairperson. Yes.
Thank you.
Perhaps, Chair, can I have a follow-up just on this?
Yes?
Good morning, Judge Cili.
Good morning.
Thank you so much. You have made me proud. But the question from my colleague is that as a traditional leader, if you assume a permanent position somewhere, the policy, as I understand, I think you understand, is that you have a power to appoint somebody to deputize
For you.
And it has got a long history, but I don't want to delay.
Yeah.
But I just want so that you understand the import of the question, because I find it somewhat maybe different in KwaZulu. If you are now acting as a judge permanently, and at the same time also acting somewhat permanently as the head of a traditional council. That is what he was seeking you to clarify.
Yeah.
And in that, trying to assist whether you had appointed a deputy, because we know that as the head of Chile, there are things that in terms of custom you need to perform. Sorry, Chair. That's the only thing that I wanted to clarify.
Thank you so much.
But you do assure us that there is absolutely no conflict between the tasks you perform there and those you perform as a judge, not even a deputy judge or a president.
There is absolutely no conflict, CJ, as I already indicated, and we don't sit regularly. We only sit when there is an issue that has to be attended to. And as I already indicated as well, we haven't sat in a very long time. And if
I don't think it really matters. The regularity of the sittings matter. If there's a conflict, then there's a conflict, even if you sit once in 10 years.
That is
If you
correct.
say there's no conflict whatsoever, then it should be fine.
Yes, there is no
Thank you.
conflict.
Just a follow-up, CJ.
Yes, JD?
Yes, thank you. Just a follow-up, Judge Cili, on this issue. So if you were to sit, you have no difficulties in delegating
Yes,
that chairpersonship to somebody who you would appoint as the deputy?
yes.
Yes, thank you.
Well, is your question a follow-up, Commissioner Ngqwetho?
No, it's not a follow-up, so
Then
I'll
join the
just
queue.
wait my turn.
Commissioner Shabangumdao?
Thank you, CJ. Good morning, Judge Cili.
Good morning, Commissioner.
Judge Cili, these days we've got a problem of sexual harassment in our courts. If appointed as a deputy judge president, how will you deal with a sexual harassment complaint in your court?
Sexual harassment complaint in my court. Firstly, it has to be reported, and once it has been reported, I'll have to deal with it in my capacity as the deputy judge president. Well,
If the judge president delegates the task to you,
if the judge president delegates the task to me.
are you satisfied with the answer, Commissioner?
Maybe
I'm looking at your face.
I'm really not satisfied. Judge, maybe if you can just elaborate further as to what steps will you take to deal with this complaint?
What steps will I take to deal with
Perhaps,
it?
in fairness to the candidate, not that I'm absolving him from answering the question, I should mention what I raised yesterday when the similar question was put to the other candidates for leadership positions, that there is actually a sexual harassment policy that is due to be disseminated to the rest of the judiciary shortly, which would be a guideline. But if he wants to go ahead and answer, then he should, without the benefit of that policy.
Yeah, without the benefit, yes.
Sorry, I'm going to answer the question, Judge Tilly.
Without the benefit of the policy, Chief Justice.
Well, there have been cases, there are pending cases now of sexual harassment
Yes.
without a sexual harassment policy.
Yes.
Do you know how the institution has been dealing with them? And if you don't know, then you can just say.
Well,
so.
there are structures in place, Chief Justice, that deal with those matters. In the establishment, there are structures in place that deal with those matters. I'm trying to think, if the matter has to come before me, at what stage will it be because they have failed, whatever the position? I'm not sure I'm going to respond to that, because there are structures in place in establishments that deal with those matters, sexual harassment matters.
Do you know which structures those are?
If a matter involving a sexual harassment has been reported, it goes to a particular manager in that section.
All right. Just let me interpose, Commissioner Shabagunda,
Yes.
please. You absolutely correct in the case of officials
Yes.
in the department,
Yes. Yeah.
the Office of the Chief Justice.
Oh.
Now, let's say an usher or a judge's secretary accuses a judge
I see.
of sexual harassment. What happens in that case?
Oh, okay. That matter will be reported to the judge president, and if the judge president sees it fit to delegate the matter to me for investigation, I'm more than welcome to do that.
CJ, could I pose a follow-up?
Yeah.
Thank you.
Sorry,
It's Commissioner Hassan.
It's Commissioner Pillay first. She raised her hand first.
Thank you, Chief Justice. Good morning, Judge Tilly.
Good morning. Good morning.
Judge Tilly, you included in your application a paper entitled Diversity at the Workplace.
Yes.
And one of the issues you deal with in that paper is the fact that managers in what you call the legal fraternity must take steps to protect equal opportunity in the workplace by eliminating unfair discrimination. I'm a bit surprised that you seem taken aback by questions relating to sexual harassment. Now that you're applying to become one of the so-called managers in the legal fraternity, did you identify sexual harassment as being one of the barriers to equality in the workplace?
I take your point. I take your point, and I agree entirely with you. Yes, sexual harassment is one of the barriers at the workplace. But as I already indicated earlier on, that if matters of that nature will have to be reported to the head of the office, and the head of the office is the judge president. And if the judge president sees it fit to delegate that matter to me, then I'll deal with it.
You see, Judge Tilly, you talk about two things. You talk about identifying barriers, and then you talk about identifying steps in order to address those barriers.
Yes.
Now, you say you accept that sexual harassment must be identified as a barrier.
Of course,
but have you considered, bearing in mind that you put up the Diversity at the Workplace paper, have you considered what kind of steps should be adopted in order to address the barriers? And I just want to add a second thing. Were you involved in the formulation of the sexual harassment policy, the judiciary's sexual harassment policy?
No, I wasn't involved in that.
let us assume that the Judge President is on leave for a year, and so it comes to you.
Yes, I'll deal with that, Commissioner Mwaitobi. I'll deal with it hands-on, head-on.
CJ, may I pose my follow-up?
Yes.
Thank you very much, Judge. I'm going to make it a little bit easier for you. I'm a junior or maybe a clerk of the court. I've experienced sexual harassment. Someone said something or touched me inappropriately, and I come to you
Yes,
as the judge president, the deputy judge president, rather.
right.
What are your next steps when I've complained to you?
You come to me to report sexual
I come
harassment?
expressly to you
Yes.
because let's assume the judge president's indisposed. I'm coming to you. What are you going to do to deal with it?
I'm going to call the person who is alleged to have sexually harassed you. I'm going to make an inquiry. Sorry, I'm going to conduct a mini investigation. If I see fit, then I'm going to suggest that that person is suspended pending the finalization of the investigation.
Take a follow-up, Chief Justice.
In terms of which legal instrument would you exercise those powers? Do you know? If you don't, you can just say so.
I don't.
Yeah.
Can I make a follow-up, Chief Justice? Sorry, Judge Tulu, I mean, just to get off this question, do you accept that sexual harassment by itself constitutes a misconduct which should be reportable to the Judicial Service Commission for
That's right.
investigation?
Yes.
And that is what you would do.
Yes.
Thank you. Why don't you say so? Why don't you simply say so? I mean, so that you get off this matter.
You are feeding the candidate the answer now, Commissioner. Yes.
Well, he says he's going to suspend the culprit himself.
I'm sorry, Commissioner Shabangumdawe, we just hijacked
Yeah.
your time.
I will leave it at that.
Okay.
Thank you, Judge T.
Commissioner Ngaito, do you still want
Thank you. Yes, I do. One of the judgments, I have 2 points to raise with you. One of the judgments you put up is the judgment of S versus Kanyele,
Yes.
which you refused bail to Kanyele, who was at the time a Fees Must Fall activist.
Yes.
I don't understand why you put that judgment up as an important judgment, given that it took an hour for the Constitutional Court to release him for 250 rand. And although there's no judgment, the questions were clear from the argument that your judgment was probably wrong.
Well, I wasn't there, firstly, Commissioner Mwaitobi, and you appeared before me when you were dealing with a bail appeal. You appeared, and I wrote a judgment, and I assume that the matter, because I assume that you approached the SCA, I assume that you approached the SCA in order for you to eventually go to the Constitutional Court. But as you say correctly so, there is no judgment in the matter. So whatever it is that you say, I cannot vouch for it. But there is no judgment in the matter.
No, I understand that. I'm not asking about that. I'm asking why you thought the judgment is significant to be put up as one of your top 10, because it was run-on-the-mill application of the bail legal principles on the facts of Mr. Kanyele.
I put it up as one of the matters which were taken up on appeal unsuccessfully, in my view, because it ended up in the Constitutional Court, and in the Constitutional Court, there was no judgment. So I put it up as one of the matters which was taken up on appeal unsuccessfully.
But what's the legal significance? What's the principle that came from your case? That's the section in the form. You've got to say this is why the judgment is important.
64. Sorry, the question is, sorry, what's the question again?
Is what is the principle in the judgment that you were trying to highlight? I mean, the fact that there was an appeal to the SCA which was not successful, but the Constitutional Court felt that he should be released, that's fine. But why did you put it up as one of your important judgments? What is the principle of law that it developed which didn't exist before?
it did not develop any point of law. I accept that. But as I've already indicated to you, I put it up as one of the matters that were taken up on appeal unsuccessfully. But when you ask me about the point of law in that matter, it was a bail appeal that served before me, and the court, the High Court, can only set aside the decision of the magistrate if the magistrate was wrong. So that was the issue that was before me. I was not able to find that the magistrate was wrong. That's the reason why I refused the appeal. But again, going back to your question, I put it up simply because I was called upon to put up matters that were unsuccessfully appealed against.
But that actually is not true, Judge Cili. You mentioned this case twice. At 16.1, you asked to list the cases where you've written judgment, not more than 10, which you regard as being the most significant, and why. And there is that case. It's listed there.
Yes, that's the point I'm trying to explore, maybe less clearly than the Chief Justice. Can you answer that question?
Well,
Oh, well, you have, sorry, the one you cite under the heading list cases that were unsuccessfully
Exactly.
appealed against
Yeah.
is a Kanyile versus the state citation with a different citation. Are they the same matters?
Yes.
The other one is just state case number whatever under significant judgments.
No, it is the same. I mean, number 6 is exactly the case that I argued. And that's what I was trying to understand. Why did you put it up? Because there was no principle there as far as I can remember.
So is it not under the cases that were unsuccessfully appealed against?
No,
CJ?
look at your application form at page 10.
Have you found it?
Yes, I have.
At item 16.1, number 6. So that's Bongingosi Kanyile's case.
This isn't right.
So can you answer then the Chief Justice's question?
Yeah, this is a mistake.
Yes, all right.
Yes.
Can I also ask
This
you
is a mistake.
No, that's fine. We all make mistakes. Can I ask you about something else?
Yes.
I was not understanding your ruling recently in S versus Zuma, where you first decided that you were not going to give written reasons for a decision not to recuse Mr. Downer.
Yeah.
And then you change your ruling and you postpone the case in order to give reasons. Now, I understand that the substance of the reasons may be a subject of appeal.
Yes.
But I'm very concerned about your consistency as a judge, where today you wake up, you say one thing, tomorrow you change it. And you are, in my view, damaging the perception of the administration of justice. What is your response to that?
I have to tread very careful when it comes to that, because that matter is sub judice.
I don't want the substance of that's what I said to you. What I'm worried about is your consistency as a judge, where you first tell a litigant, I'm going to do X, then you change and you say, I'm going to do Y. People want to know that when judges say X, they mean it.
Well, I had my reasons, Commissioner Waitobi, which I don't think it will be appropriate of me to say now.
Are they part of the appeal? Your reasons for changing your mind?
Yeah.
They
Well,
are?
yeah.
Okay. Well, in that case, you should not answer them.
All right, fine. Thank you, Chief Justice.
Commissioner Mangena, you had your hand up.
I had my hand up, Chief Justice, and I just did not want to
disturb other commissioners with follow-ups. Judge
Clearly.
Yes.
how are you?
I'm good, I'm good.
Good. I've got a question relating to reserve judgments. The JP and Commissioner Hassan
Yes.
asked you about this. And my questions are actually focused on transparency in the judiciary, judicial accountability, as well as public interest. You would know that ground up lists reserved judgments and invites members of the public to submit comments or to submit matters where judgments have been reserved for a long period. And I, in all fairness, thought that I should ask you this question because there are two matters listed in ground up that shows that you reserve judgments for more than 1 year, 2 months in both of them. Are you aware of those matters, number one?
I think the other one is a criminal matter where I wrote judgment for the full court.
There's no criminal matter here. It's NE Zondo versus SV Lagasi.
I see.
And
Right.
20 others. The other one is N Mangaru versus Minister of Police. So I would want to assume both of them are civil cases.
Right.
And Commissioner Hassan asked you if you've got difficulty with judgment writing. But you'd know that if these matters are listed on ground up, the public would want to know why would the JSC appoint a judge to be the deputy judge president when that judge is not able to account for his matters through his judgments.
Let me begin by saying that as far as I'm concerned, I'm doing very well with regards to the reserve judgments. Then Zondi, I remember, is it Zondi or Zondo? Zondi. Is it Zondi or Zondo? In this matter, I remember it very well. What happened in this matter is I had the matter, and after having had the matter, the parties indicated that they were going to settle the matter. So they forwarded documentation to say that they are going to settle the matter. Then thereafter, they decided to change their minds. So when they said the matter was going to settle, after having heard it, I shelved it, I put it aside. And it was only after they changed their minds that I decided to write the judgment in the matter. The Mangaru matter, that's a Durban matter. Counsel in this matter, after it was a trial, this one, Mangaru, it was a trial. Counsel indicated in this matter that they wanted to introduce further evidence. I was very reluctant to allow that, but I gave them time. And when they approached me in chambers very late, after having indicated that they were going to lead further evidence, it was late at the time, then I decided I'm not going to allow them the opportunity to lead further evidence. That's the reason why the matter was delayed. Immediately thereafter, I wrote the judgment in the matter.
Thank you, Chief Justice.
There is also another matter. I think it's not coming up because it really worried me. I even discussed this matter with the JP. The reason why I'm saying this is because I don't want to leave an impression that I have a problem with writing reserve judgments. There is also another matter that involves, it's a criminal matter. I reported that matter to the judge president. I finished writing judgment. I was describing the matter. It was a full court judgment. I was described sitting with one of my colleagues who is a permanent judge and the other colleague who is an acting judge. Having scribed that matter, I finished scribing the matter. I approached a colleague, the permanent judge. We finalized the draft. Then we sent the draft to the acting judge. It took months until I had to report the matter to the judge president. But the judge president at the time had to report the matter to Judge Matondo, who was the acting at the time. So that is one of the matters that was reserved for a long time, but it was due to no fault on my part.
No, fair enough.
Yes.
I thought I should put that question to you because when somebody reads ground up and is not aware of that explanation,
Yes.
the impression he or she is left with is that this is a judge who has difficulty delivering judgments.
Yes,
Thank you so much.
You're welcome.
Thank you, Commissioner Mangen. I don't think you need to worry in respect of the last line of questioning, just really.
Yes.
I've no doubt that if you were a delinquent who delayed delivering judgments, JP Boyotwati would have raised that concern with you. Just to, Commissioner Marumakhai, do you have a question for this candidate? At all. Thank you. Commissioner Breitenbach, do you have questions for the candidate?
Good morning, Chief Justice. Thank you. Now I'm covered.
Thank you, Commissioner. All right, just to round off, Judge Trilly,
Yes.
I just want to probe a bit deeper, but we have to do it briefly, into the issue you identified as your biggest concern in the division. I'm quite worried by the revelation of disunity in your division, and I would just like you to explain to us, just in brief terms, how it manifests itself and if it does not affect the efficiency of your operations down there.
Well, it doesn't now because the present judge president has dealt with it. But there was a moment where there was that division in the division I don't want to delve into depths with regards to that, perhaps as to the source of that, but perhaps in private, I don't know, we can talk about it. But there was that division, but the judge president, as I already indicated, has dealt with it. And as already,
so there is no longer disunity?
There isn't
Oh,
disunity
right.
anymore. There isn't.
Then what you said misled me, I'm sorry.
No.
All right, Commissioner Kotsa?
Sorry, I tried to get your attention earlier, CJ. I just wanted to go back to the reserve judgments, if I may.
Yes.
Okay. Good morning, Judge.
Good morning.
I just want to follow up in the second application by Mr. Zuma for the removal of Billy Downer.
Yes.
You delivered a relatively simple ruling, but that ruling took 5 months to deliver. Can you explain why it took 5 months?
I did second most of the time.
Excuse me?
I did second most of the time. Second duties.
Maybe just explain to the commissioner what second duty is.
If you are out of the office, if you are working out of the office, doing criminal work outside of the office.
Yeah, I understand that, but the question is, it was a very brief ruling. Why does that take 5 months?
Which one? Which ruling are you talking about?
The second application by the former President Zuma to have Billy Downer removed.
Oh.
It's the one you gave on the 11th of September.
Can I just try to clarify for Judge Trilly? So that he can I'm not going to answer, don't worry.
No, CJ, no. The question has been put before a candidate. He must answer for himself. Please.
The JP has said she's not going to answer the question for the candidate, and I'd like to think that she means what she says. So I will give her a chance to give the explanation. Go ahead, JP.
Yes, and may we be protected from Commissioner Malema because you are the one that must rule on the issues. Judge, clearly the question was, you reserved a ruling after argument. So what I wanted to assist with, was that in the course of a criminal trial or was in the course of an opposed application?
It was in the course of a criminal trial.
CJ, may I? I don't know what protection do they seek from you against me. Exactly what I anticipated. Commissioner has asked a question. The question is not being answered because she says she's going to try and clarify the issue without answering for him. Instead of doing that, she asked another question on top of the question of the commissioner, which is not answered. And we're looking for answers for that.
Sorry, can I respond to this, please? That's
Respond, Judge.
yes. I initially stated to the commissioner, I asked a question that I was doing circuit duties. And when you're doing circuit duties, you are not in court, you work outside of the court. It was a criminal matter, it was an application brought in a criminal matter, and I had to avail myself to deal with that matter. I would not have reserved judgment and given the judgment to another judge to hand it down. So I will have to be available in order for me to hand down the judgment because it's a criminal matter. It's an application that was brought during the course of a criminal trial.
Commissioner Gotsa?
I will, I understand what circuit duties are.
Oh,
CJ,
thank
but-
you. No, okay.
I was a judge's registrar for a very long time.
Oh,
but-
yeah, you did say.
But it doesn't really answer the question, but I will leave it.
All right, that is the answer. We'll assess the candidate on how he responded. If the merits and demerits thereof, we'll deal with later. Was there another hand? No? All right, then, no, for making yourself available for this position. Unless there's anything you wish to raise with us, you are free to go.
Thank you,
Okay.
CJ.
Thank you. Take a quick tea break. Comfort break. Well,
The GCB is already taking the adjournment.
Okay, let's take a quick comfort break then. Stretch our legs.
How long?
Well, not just here. Okay. Yeah. Okay. Oh, okay.
One of the things that is holding here for. A lot of things that are happening.
Commissioners.
We are waiting for the members of the objections committee to finish their conversation so that you can start interviewing the candidate.
Good morning.
Oh, my mic is not on. Good morning, Just Ghost.
Good morning, CJ and commissioners.
How are you today?
I'm okay, Commissioner.
Good to hear.
Yes.
You have applied for which position? Deputy Judge President of the KwaZulu-Natal Division of the High Court?
Yes.
Right. We have the right person then. You have 3 degrees, a BUris, LLB, and LLM.
Yes,
May I ask from which universities you obtained these qualifications? It's not quite clear from the application form.
The first 2 degrees, BUris, LLB, I obtained them from UNISA. And LLM from Nelson Mandela University in Port Elizabeth.
And I'm looking at your timeline, your employment timeline, and I see that you would have been studying part-time while working during the day.
Yes.
How did you manage that?
Well, you have to make time. If you plan your things accordingly, you will be able to achieve quite a lot.
Tells me that you are good with time management.
I try to
All right, so you started working for the Department of Justice quite early on in 1978.
Yes.
You were a court interpreter slash
Clerk, yes.
administration clerk.
Yes, we would perform functions in court during court hours, and after that go to do filing, also the clerk of the court work.
Also that the clerk stands for clerk of the court?
Yes.
All right. And you were in that position for 7 years?
Yes, I was.
Then you joined?
That was whilst I was studying.
Yes.
Towards BUris.
And then you became a public prosecutor, but that was only for a year? Yeah, or 2?
Actually, it was 6 months. I joined the KwaZulu government whilst we still had commissioners' court. So I was there for 6 months, and then the Black Administration Act was amended, abolishing the commissioners' court. I then became, because after 6 months I became an assistant commissioner. As you would remember, during those years, a black person could not be a commissioner. You had to be an assistant commissioner there had to be a white person who was a commissioner. So I became assistant commissioner for a short period of about, I think it was 4 months, if not 5 months. Then the commissioners' courts were abolished. We all became additional magistrates after that.
All right. And you joined the magistracy and worked your way through that office as additional magistrate for a period of 12 years.
Yes.
What kind of work did you do during that period? Criminal or both
Criminal
criminal
work,
and
civil work,
Civil as well.
quasi-judicial work. In fact, at the beginning, as you would see in my CV, we would also do administrative work, supervising the supporting staff, because at the time, the departments had not been separated. We still had labor courts, and, labor, family courts, all those divisions that were later separated from the Department of Justice. So at the time, the work that I did was not just being a magistrate.
Yeah.
You do almost everything in the office.
When you became a regional magistrate in 1998 and remained in that position for 13 years, the CV
Yes.
says, until you became a judge of the High
Yes.
Court in 2011.
Yes.
Your form, your application form is not specific. Does 2011 reflect the date of permanent appointment?
It is, yes.
Okay. Had you acted as a judge before that
I
time?
acted from 2010.
From 2010. For how long?
I think it was for 3 or 4 terms.
Almost the whole year.
Yes.
All right. So that would mean then you have about 4 years judicial experience as a High Court judge under your belt, including
Yes.
the acting stint. All right. You've done a whole lot of other things. First, before I get there, you've acted as a deputy judge president.
I have for
how long?
last year it was for 1 term, and this year for 1 session.
Okay. And what kind of tasks did you perform to assist the judge president during those 2 stints?
Well, I performed all the functions the judge president is supposed to perform, starting from the bottom, preparing rosters and allocating work to judges, dealing with administration, dealing with all the complaints that are brought to the division.
And the judge president was satisfied with your performance?
I think so,
Or
because
is it for her to say?
because she never complained, and I received a positive feedback.
All right. I see that you have a whole bag full of other skills that
Yes.
would be useful in a leadership position. You've listed 2 pages worth
Yes.
of all the training sessions you've undergone, and those importantly include a leadership course you did first a workshop on case flow management
Yes.
in 2005. Then you did a leadership course in 2007.
Yes.
And then more recently, but not so recent, in 2015, you attended a seminar on judicial case management, amongst other subjects that were
Yes.
that were offered during that seminar. Did you find that experience useful? Do you think those skills would assist if you were lucky enough to get appointed? for
Yes,
this position?
particularly when it comes to cash flow management, because we cannot talk of quality access to justice without an effective and efficient cash flow management.
All right. I'm not going to ask you about the judgments you've written in your 14 years as a judge. All the professional bodies have spoken highly. They
Yes.
commend you highly for the quality of work you produce.
Thank you.
On what they say is a wide is the widest legal spectrum.
Yes.
I just want you to tell us as briefly as you can what plans you may have to improve the efficiency of the division's operations in collaboration with the judge president in this position, if you get it. Challenges you may have identified and propose solutions. But as you do that, I would ask you to keep in mind, just take into consideration Saula's request to us. I can't find it now, I'm sorry. But they wanted, you would have read the papers, they wanted us to question you closely on what benefits you would bring into this leadership position. So if you could just take us through your vision.
The division has lost many senior judges, and we had to make do with acting judges most of the time. So the first thing that should happen is we should appoint more permanent judges, because there are problems with acting judges in a long run, because they have other private engagements, and that sometimes may cause a delay in finalizing some of the matters. We also have an extensive caseload. I think we would need to have more judges to help deal with those matters expediently. We have a problem with the RAF matters. The lead time, I think we are now in 2027. We're about to go to 2028. So that's the problem I've noticed as I was acting, that we need to deal with those, with RAF roles. Now, the way I look at it, what I've noticed is that the problem in resolving these matters speedily is not about so much about the complexity of these matters, but it's about the time that both litigants need to discuss these matters. What I've noticed is that if you give them time, either during the cash flow management or during the RAF role, which we used to have, and in that role, I would give them time or a date to talk, and if they talk, 90% of those matters are resolved. And they advised me that it's just the time to get together to discuss these matters that they need. Now, that would help us with the lead times for trial matters, because most matters will be settled. I think that's about all that I can mention now. But we still have to also to improve on our pre-trial conferences, because that would also help to finalize matters speedily. If it is effective and efficient, that should help us to finalize matters speedily. We have done, I chair the Court Performance Committee, and I've identified those problems that, as to where the problems lie, and as to what should be done to alleviate delays. Because in particular, criminal matters, you get many problems pertaining to counsel not being available, or counsel that was there withdrawing and another one taking over. That also delays the proceedings. Same thing applies to civil matters. As I say, I try to give them more time in court to resolve those matters. And if they can't, only then can one look for a date to set down the matter for a hearing. But most, I'm talking about RAF matters, but most of those matters can be resolved without a trial.
I found the solar commentary, and you've answered half of what they wanted us to raise with you, but they ask that you be questioned on how you would effectively use mediation in the context of increasing litigation against available resources in terms of courts and the number of judges, which you've lamented. Have you had occasion to use mediation in resolving matters?
Let me put it this way, sorry.
What is your view on mediation? Let's start there.
Parties do approach me in chambers and tell me what is the dispute between them. And sometimes I indicate to them that if the problem is this specific problem, perhaps the best way of resolving it is that way. If they can't resolve it, obviously I have to resolve it myself. Usually it is narrow issues that they actually want resolved. But I always encourage parties to mediate, even during case flow management, that the parties should go and talk. If they can't talk or don't agree, maybe find a mediator to do so on their behalf. But I've noticed that without finding an outside mediator, they are actually able to resolve the issues in those matters.
All right. You listed a reserve judgment in your application form, which you undertook to deliver shortly after you submitted the form. Was it delivered?
Yes, no, it was delivered at end of June, beginning of July.
All right. One last thing for now. A concern that has been raised by two professional bodies, the BLA and NATEL, concerns your age, which they term advanced. How old are you?
66.
Should that be held against you?
I don't think so, because there's a lot that one can achieve in 4 years' time. The programs and projects that we may introduce to improve access to justice are not things that would take forever to be implemented, are things that we would discuss and implement immediately, and that should benefit the division. So also maybe I should mention that it would not be a bad thing to balance the gender scale. I get on well with the JP. She's actually the good head and a good heart. I think I also have those attributes. We should be complementing each other very well if I'm bound to be fit to be appointed as the Deputy Judge President.
All right, just one last aspect I did not cover. You initiated and led a project to establish an intermediary room in the Sexual Offences Court in Scottsburg.
Yes, that was whilst I was a regional magistrate there,
Yes.
and it is still operational.
Where did you get that idea from?
Sorry?
Where did you get that brilliant idea from?
It was in my court. I could see that only all tables were put there in that room, and I thought, this is not good for children. I should ask some of my colleagues for help, the local business people to help. I also got an artist to decorate the walls and others to donate dolls and things like that in the room, you know, just to lighten up the mood for the children when they get there. Still working till today. I'm happy to say that sometimes if I do go there, I see that it's still working very well.
Good to hear. All right, I'll hand over to the Judge President to put questions to you, if she has any, that is.
Thank you, Chief Justice. Yes, thank you. I do have. Good morning, Judge Ngosi.
Good morning, JP.
Yes, I do confirm we work well together, and I have not received any complaints about you. And also, when I was perusing your papers, I saw that I'm younger than your firstborn, but I have never felt that way. You have treated me with the respect that the office requires, and I appreciate that.
Yes.
Yes. Just on the reserve judgments, I see that your name had appeared previously 2021, 2022 on the list. But after my appointment as the JP, that is 2023, I haven't seen your name appearing on a list for more than 6 months or so. Is that correct?
Yes, that's correct, JP.
Yes, yes. And the one that was taking longer for you to do was the inquest, and you asked for time out. If I recall, you were due to go on leave, but you postponed it so that you can deal with the judgment.
That's right. In fact, it was at the time I was acting as a DJP that I delivered it.
Yes.
But I needed time before that in anticipation that I would be quite busy as the ADJP. That's why I needed that week to prepare the judgment.
Yes, thank you. Now, you've mentioned when the CJ was asking you certain questions about some of the challenges that we have in the division, particularly the RAF and some of the criminal matters. Just on the criminal matters, what's your view? Do you think we have a backlog or we don't have a backlog?
We do have a backlog, especially on circuits. The last time I was there, I had about 4 or 5 backlog matters. I managed to deal with 3 of them and finish them. Others had to be adjourned because either council was not change of council. So a new council had to take over. But at least I managed to do 3 and finish them. But we do have a backlog. I think if we get a division in Richards Bay, where we would have 2 criminal courts maybe and 2 civil courts, and maybe another deputy judge president heading that division, that will go a long way in bringing justice to people of that area, especially with regard to criminal matters. I know we don't have too many civil matters coming from that area, but who knows what might happen if we open that court and people know that justice is just next door to them. We may get more civil matters coming from that area.
Thank you. Then on the RAF matters, any practical suggestions on how you would, if you were appointed, you would deal with the issue of trying to alleviate and try to shorten the lead time, which you have correctly said is about 2027 for now for trial?
The only way to deal with that would be to do a proper case flow management. As I say, to encourage parties to discuss the matter and see where they differ, where the differences are, and try and resolve it. Because until we get more judges, which I'm hoping we might get in the near future, we'll have to make do with the only judges we have. And just improve on what we're doing. Make sure that we finalize matters as soon as possible. No unnecessary delays. I think for now, that's the only way we can try and, address. Because if matters are finalized, obviously spaces do open, and then new matters can be dealt with.
Yes. Then just on the reserve, not the reserve, the parted matter, and Ikaluza, and the Minister of Police, I see that it's due to continue from 21 October, but when had it started?
I think it started last year. No, in November, I think we started it last year.
Right. And I note what you have stated about supervising some of the staff matters of the staff, because this is a managerial and a leadership position. Any other managerial or leadership skills that you have other than those?
Yes. Obviously, I managed the work of magistrates before. It was not just about the supporting staff. I'm talking about criminal and civil matters when I was still a magistrate. I also I was a training officer, training magistrate and prosecutors and support staff. Now, that needs managerial skills. But I have also, now that you gave me the opportunity, I have also learned how to manage things, personnel, work in the High Court.
Yes. Just on the one for supervising magistrates, particularly the regional court, because you were a regional court magistrate.
Yes.
We have a problem with the finalization rate and also the court hours. How was it then when you were a magistrate, and what helped to try to, if there was a maximum sitting period, what helped you to get to that? Because now we battle to get 1.5 hours on average a month.
Well, with the regional court, especially those who are not based at the center in Durban, because we were all based at Durban Center, and then we are assigned to different regional courts to perform our functions. You do that, you control everything there on your own. I didn't have too much of a problem at the time in my regional court, but I see that at the time the emphasis was not on case flow management, an effective and efficient case flow management. So we did have that conference with them, and we emphasized case flow, effective case flow management, and because the president was also there, was also involved. So I think sometimes magistrates allow matters to be adjourned easily. I say sometimes. One would not know why the matters are adjourned and people sit only for 1.5 hours. But it comes back to the effective and efficient case flow management. If you do it correctly at the beginning, you should be able to deal with those matters and finalize them speedily. You do get those long ones, long matters that may take time. But if you have done the planning correctly at the beginning, you should be able to finalize those cases within reasonable time.
Thank you. And then I think just 2 more questions. One about Dr. Ghani. The one that I'm concerned about is the one where she says you treated a white male counsel differently to a black counsel that appeared before you. What's your comment to that? I don't know whether in relation to that one matter that she's complaining about.
A white male counsel,
Yes,
and the other one was black.
yes.
No, it was both white counsel. The other one was a lady, and just for her information, I must say that I actually worship the ground she walks on, that lady walks on, because she thought maybe I didn't treat her well, but that was not so. I treated them equally, but the unfortunate part is that the party involved was her son. So maybe that is why she thought, I was being hard on the lady who was counsel for her son. But I treat everybody equally. You can ask any other person who knows me, they'll confirm what I'm saying. So I do not know where that comes from. Maybe it's because she was emotionally involved in the matter.
Yes. And then lastly, with regard to the comments by Saula about the gender gender, that your appointment would not advance gender transformation
Yeah.
on the bench. And your comment partly was it would balance the gender representativity. It probably would also balance the age representativity.
I think so, yes.
Yes, but in light of the fact that there are now two male candidates, being yourself and Judge Chili, what's your comment on that? Is there any comment that you have?
Well, if Judge Kelly is the best candidate, please recommend him. If I'm the best candidate, I'll be happy to be recommended. So I do not have a problem with Judge Kelly being involved as well. Obviously, it is your decision. You decide who would fit the post best under the circumstances.
Thank you. It is the decision of this body, not mine. Thank you, Judge Nkosi.
Thank you, JP. Do you have questions for the candidate, Premier?
Thank you, Chief Justice. I do have a question. Good day, Judge Nkosi.
Good day, Premier.
No, I just have a general question to understand you better.
Yes.
You have acted as the Deputy Judge President in the province. I just want to understand your noticeable or remarkable inputs to the division during your acting, and wish to understand how do you think that can assist the division in the future. The noticeable, if there are any noticeable or remarkable inputs in the division.
Well, the inputs will be general inputs that I expected of a Deputy Judge President. Working hard, being up to date in everything, making sure that courts are functioning properly, everybody is on board. I did all of that, and it worked. And everybody was happy to have me on board. I'm not going to quote anybody, but everybody was happy to have me on board. Other things still have to work through them to improve access to courts, analyzing things quickly. Also how you accept members of the public. People are happy because that's who I am. So I don't think there could be anything more than what is expected of a Deputy Judge President to do correctly. I think I did all that. I don't know if I've answered your question.
No, I hope so. Thank you, Chief Justice.
Thank you, Premier. Do you have questions for the candidate colleagues? Commissioner Nokesi?
Thank you, CJ, and good afternoon, Judge Ngosi.
Good afternoon, Commissioner Nokesi.
Yeah, to be fair, let me ask you the same question I asked from Judge Chili. Can you talk on the importance of relations between judges, staff, and the other stakeholders?
The importance of?
The importance of the relations between staff and the stakeholders.
there should be harmony. I think we are the strongest when there is harmony. It's very important. There's very little you will do if there's no harmony. So I am the type of a person who makes sure there is harmony and that work is done.
Yeah, I just want you to comment on this. Unfortunately, when I was there in KZN, you were not there.
I understand you were in Peter Marisbeek, I was in Durban.
Yeah. I find something unique for KZN where judges on Thursday would come together,
Collegiality, yes.
have lunch and all that. How that enhances the relations among judges themselves, and how does it strengthen the unity of the division, and how, yes, that's the first part of the question. The last part of the question is, Judge Clearly had indicated that at some stage there was disunity in the division. Do you confirm that? If you do, what is the position now?
Well, I don't know if I should call it disunity. And I'm not sure during what period there was this disunity. Perhaps
before the coming of the current JP.
Oh, yes. Well, very few individuals were involved in that. Very few individuals were involved, and I think one of them did sit here during those interviews. Other than that, there was not so much disunity. It's just individual, who maybe had a preferred candidate, I do not know. But I tried not to get involved in such things.
Thank you, CJ. Thank you. That's all
Thank you,
from me.
Commissioner Nokisi. Just to follow up on your last comment, Judge Nkosi, you say you don't get involved in such issues. What do you mean by that?
So, if somebody says, I like this candidate and not this candidate, I always avoid engaging people on those topics, because it's not a question of whether you like the candidate or you don't like the candidate. So I supported both candidates at the time. I didn't choose sides. This is what I mean.
All right, so you reference only in one example. Was that the only source of disunity? That there were two candidates?
As far as I know, that was the only source.
All right. But I raised this question because you are applying for a leadership position, and if there is trouble in the division, then it would be your responsibility, resting squarely on your shoulders, to deal with such issues immediately.
Agreed.
And not avoid them.
Agreed, CJ.
Okay.
But collegiality, I always promote collegiality, even amongst those who don't agree.
All right. That comforts me. Thank you, Judge. Commissioner Ngwaitobi?
Yes, good morning, Judge Nkosi.
Good morning, Commissioner Ngwaitobi.
Yes, now it's just to follow up on the exchange you had with the Judge President, particularly on that objection by Ghani.
Yes.
So I hear your point that you worship the ground on which Advocate Julian walks. But I think the real issue is whether you respect her as an advocate in the equal way with the male advocates, because I don't think advocates are interested in whether judges worship the ground on which they walk. What they want is to be treated with respect.
Yes,
That's
no.
that's the nub of the issue. Can you just assure us on that issue?
Oh, yes. I'm a very respectful person. Very respectful. I would never treat people differently because of who they are. In terms of gender, in terms of race, in terms of religion. So that's why I said I worship the ground she walks on, because I wanted to make a strong statement that I would never have done so with her. She's a very brilliant counsel, very brilliant. And I would never discriminate against her at all.
All right, that's fine. I mean, that's your answer to the objection. Then there is a second part to that objection, which is that you gave an order, I think it's on the 13th of, or the 17th of August, 2023 in open court. A request was then made for a written order and a follow-up to the office of the judge president in March 2024. Nothing happened. It only surfaced on the, I think sometime in July 2024, which then frustrated their ability to ask for leave to appeal, which implicates you now as a DJP in delays, as an aspirant DJP in delays. How do you answer that part of the objection?
No, I think the order they were asking for pertained to a divorce decree. It was not an interlocutory order that I granted last 2023. Was it 2022? I think I started that matter.
No, this one is 17th October 2023. But in your response, just to help you, you admit that there was a delay, but you say that it was not your fault. It was at the registrar's office.
Oh, yes. Oh, yeah. Yes. I think that was the final order, if I'm not mistaken. Was that not the final order? If I remember, it was the final order, which should have been.
But when your response says the required date, this required a date convenient to all the parties, the first being the 2nd of March 2023, oral submissions were made on the 14th of March 2023, and the judgment was handed down on 17 October 2023, just outside of the 6 months norm because of a hectic acting stint I had as an acting DJP. A significant issue of an extended delay in issuing the court order following upon the delivery of 17 October 2023 is also raised. So that is what you admit, and then you say, but
Oh, yes.
they should not have asked me, they should have asked the administrative people.
Yeah. No, what should have happened there, once the judgment had been given and the order granted, the attorney who represented the party should have approached the registrar for the order to be typed. Now, such complaints are usually dealt with at that administrative level. Nobody ever came back to me to say, by the way, judgment is out, we have still not received the order, in which instance I would have asked my registrar to check and help them to find out where is the delay.
Except that they accuse you of being obstructive in the obtaining of the order, which implies that they did
It
tell
was
you.
incorrect of them to do so. It's not a judge's function. It's not a judge's function to issue orders. I mean to make sure parties get orders. I had finished my part, gave judgment with the order. All that the attorney for the party should have done was to approach the registrar to get the order typed.
Look, I'm sorry about this. They said, look, you've given an order, ex tempore, fine. We've then asked you for the written order, and then you disappeared on us.
No, no, that is incorrect. The facts are incorrect.
Yes, no, that's what you say in your response, but I'm just giving you a chance to
Okay.
elucidate to us.
Okay, no, that is incorrect. I never gave any extempore judgment in that matter, save at the beginning of the hearing, of the trial. Because that related to the access rights. So I gave that order, extempore, yes, extempore, before we started the trial. And there was never an indication that anybody wanted to appeal. It was not appealable anyway. It was an interlocutory order, which was not appealable because it only related to the access rights to the child, whilst the trial is running. So I didn't understand the complainant to be referring to that order.
Yes, but I thought that you and the complainant are at idem, that there is a judgment or an order you gave on the 17th of October. They asked for a written document proving it. You were nowhere to be found.
Oh.
And then you then say in your response, it was not my job, it was the administrative staff.
No, I thought she was referring to the last order that I made. And they applied for leave to appeal, as you know. And I granted that. No, I didn't grant the leave to appeal, but there was one issue that is still outstanding in that matter, which relates to costs. And I know that matter is still sub judice because they are likely going to the SCA.
Right. Just the last point on this. I mean, what I'm really trying to get to is an explanation of the delay between October 2023 and July 2024 in them getting a document from the court. Whether you're saying, well, that's true, but it's not my problem, it's someone else's problem, or it's not true. So I'm just trying to, I'm not trying to catch you, I'm just trying to, you to give an explanation.
All right. Actually, I heard about that delay for the first time when the complaint was sent to me. I didn't know anything about that
In these
delay.
proceedings, in this interview?
Yes.
Okay.
Nobody ever approached me about any delay. So I would have helped if somebody approached me. Although it was attorney's job to approach the registrar, but I would have helped because I always do help parties who need help. That is part of my job.
So the real answer is it didn't come to your attention.
Sorry?
The real answer is it didn't come to your attention. It's not this thing that it was not your problem, but just no one brought it to your attention. That's the real answer.
I just didn't understand how an attorney would not approach the registrar to get the order. And I'm only hearing it for the first time because of this interview. So I just didn't understand how it happened. And unfortunately, as I said, nobody approached me to say, Judge, please help us. The registrar is not helping us with this, to type this order or to issue it because it is issued by them.
Thank you, Sir.
CJ, may I follow up, please?
All right. Let me just ask mine first. Just really, I'm sorry, I missed part of I got distracted. I missed part of the engagement you had with Commissioner Nkaito. Do you say you handed down this order in open court?
Yes,
So it was only the typing and the
that's
admin
right.
side of it that was outstanding?
That's right.
All right. No, that edifies my concern. But I just still want to raise something with you. You made a comment that you had done your part. Now it was for somebody else to ensure that the order was disseminated to the party or the parties. But I just want to caution you that you're applying for a leadership position, and ultimately the buck about everything that happens in that division rests at your door,
Yes.
and the JP's door. So it is your responsibility. If there are failures in the registrar's office, for example, when parties complain, you're not going to point fingers at the registrar. You should have measures in place to
Yes.
ensure that the registrar and whoever, all the the administration staff, actually perform their duties.
Yes.
And it's just your duty to do that.
Yes. Unfortunately, I was not aware of this complaint. I always
But you
attend.
do realize that when you assume a leadership position, you will assume the duty to ensure that those orders are actually
Certainly.
sent to the parties.
Certainly, CJ.
You understand that?
Yes, no, I do.
All right. Well, that's what judges do at the Constitutional Court. We have the staff who is paid to do that job, but things fall through the cracks, and you can't afford that.
Yes.
So the responsibility rests on us to ensure that the court does its work to finality properly.
Yes.
Okay. JP Mlambo.
Thank you, CJ. Good afternoon, Judge Nkosi.
Good afternoon, JP.
This is just a follow-up on this line of questioning, but the CJ has partly covered me. But what I want to check is, when you acted as DJP, didn't you have occasion to check the turnaround times in terms of which parties get their orders? Let me give you the context. In Gauteng, the turnaround time is 7 days. We have an electronic management system, and the secretaries, judges' secretaries know, and their judges know, that all orders granted in their courts have to be uploaded and provided to the parties not later than 7 days. So I'm just asking you, during your stint as acting DJP, whether you had occasion to look at this or whether you have a system.
We unfortunately do not have a system in that division. But I suppose I'll have to, if you find that I'm the candidate for the position, I'll have to implement that.
Okay, thank you, CJ.
JP?
Thank you, CJ. I am covered, but just for certainty, Judge Nkosi, I wanted to confirm, to just check with you in the ordinary course. Once you have granted an order as a judge, what happens then?
Well, the file is taken to the typist to type the order.
Yes.
So that when an attorney phones to find out whether the order is ready, has been issued, they can then come and collect it.
And as you say, if you were aware that there was an issue with the order, you would have assisted.
I would have sent my registrar or secretary to go and check and solve that problem.
Yes, and just to confirm, CJ, also, I saw my name is mentioned in that letter. I never saw that complaint as well on my desk about this order.
Yes.
Thank you, CJ.
Thank you, JP. So it rests on the parties to collect the order from the court. The registrar does not send the orders to parties.
Well, it depends on the arrangement between the register. It goes to be typed, and then it is issued. I do not know if they send it to the parties or the attorneys come and collect it. I'm not so sure
You're not
about.
sure. And in the case of a party, a self-representing party, do you know what happens?
Sorry?
In the case of a party that represents themselves, what happens? Where there's no attorney.
Yes. So that's why I say, if I am appointed a DJP, I'll make sure that that process is streamlined.
Yes, clearly there's a gap in your
Yes.
systems. And the court has actually, it has a duty to send its orders to the parties.
Yes.
If the parties choose to make its work lighter by collecting them, that's
Yeah.
fine. But the registrar should dispatch orders to the parties.
Yes, no, I agree.
Thank you, DJP. Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Nkosi.
Good afternoon, Commissioner.
Judge, on my calculation, you've been a judge for 13 years now.
Yes.
Can I ask you to look at paragraph 16 of your questionnaire?
16.
1-6, and you'll find that at page 10.
Yes.
You ask there at 16.1, Judge, to list the cases where you have written the judgment which you regard as being the most significant. And it stated not more than 10. But you only provide, you're one of the unusual applicants that only provide 8 cases.
I could have given more. I read somewhere that they mention about not less than 3 or something like that. So I thought maybe 8 cases would do.
So we are not to deduce from that you only have 8 significant judgments.
Oh, no, there
are more.
there's many more.
All right.
As you can see from the Safili list that is also attached. No, I didn't attach it. There are actually many more that are on Safili.
So I just want to tell you that the immediate impression or the concern that jumped out at me when I read this was one about work rate.
Oh, okay, no.
And it was calcified by your next answer, which the question is which of these cases have been reported? And you indicate that only one of your judgments have been reported. Or is it
Yes.
only one of the 8?
Only one of the 8. There was another one reported. Don't know why it doesn't show, but it's the matter that was decided by the full court of the Mpumalanga. They obviously overruled my judgment. So that is why it doesn't appear here.
So how many reported cases do you have?
Oh, it's
Judge?
only 2.
You've got 2 reported cases.
Yes.
Then, if you look further on, you asked at 16.3 and 16.4 to list the cases, list the judgments which were unsuccessfully appealed in 16.3, and you say none.
Yes.
And in 16.4, you asked to list the cases where your judgments which were successfully appealed, and you say none.
No, this was not an appeal. It's another division. Full court of another decision changed my decision.
No, I accept that, but what the questionnaire is asking you is to list which of your judgments were successfully appealed and which of your judgments were unsuccessfully appealed. And in relation to both questions, you answer none.
Yes, because none were successfully appealed.
So in 13 years, not one of your judgments have been appealed?
No. Well, some I do not know, because judges are not told which matters went on appeal, which ones. They are supposed to be told, but we only hear when the matter returns, either from the SCA or from the Constitutional Court, as to the outcome of the matter, but I'm not aware of any.
And unsuccessfully appealed?
Well, sometimes none were unsuccessfully appealed because sometimes a judge would never know which matters did eventually go on appeal.
I'm so confused, Judge, because you're now saying none are successfully appealed and none are unsuccessfully appealed.
Yes.
In how many of your matters have you granted leave to appeal?
Well, I don't remember, but quite a few. Very few.
For the 13 years, very few
Yes.
leave to appeals.
Very few, because parties, that doesn't stop the parties eventually to go on appeal if they want to seek a special leave to appeal. But of those that I allowed to go on appeal for a good reason, none were successfully appealed.
So all of the appeals were dismissed?
Sorry?
All of the appeals were dismissed?
Yes.
But that does mean that your answer is incorrect when it asks you how many of your judgments were unsuccessfully appealed.
Well, yes, I think maybe the question was not very clear to me.
In the questionnaire or my question?
No.
Oh.
I'm talking about the question here that, yeah, if I remember well, I think the PLA, not the PLA, did mention one matter which went to the SCA, which that was in 2013, I think. When I was still a young judge, I'd forgotten about that matter.
So just a final question, Judge. In your division, is it not unusual to only have 2 reported decisions in 13 years? 2 reported judgments in 13 years?
No, it is not. It is not, because we usually send matters for reporting which raises a novel issue or a new issue, or which explains another issue which may not have been clear before. And how we do it, all our prepared judgments, reserved judgments, we give them to the people who look into our judgments, who correct them, and their senior receives those matters and make them available to the reporting houses to see whether should this judgment be reported or not.
Thank you, CJ.
Thank you, Commissioner Pillay. Any more questions? Oh, sorry, there's DP Zondi first.
All right, thank you, CJ. Good afternoon, Judge Nkosi.
Good afternoon, President.
I've just got one question and just a comment. The first question arises out of your engagement with Commissioner Pillay. Now, regarding your judgment that have been appealed against, successful appeal against. And then in your statement you said the judge will not know which matters go on appeal. But surely before a litigant can take the matter on appeal, that litigant will have to approach you and apply for leave to appeal. Is that not so?
Yes, that's true.
So obviously, then you would know that this matter, I granted leave on this matter, or if you refuse leave,
Yes.
then that's it.
Yes.
Okay. And then my second question relates to the issues which you identified as challenges in your court. Now, those issues or those challenges and the manner in which you want to address them, is it part and parcel of the vision of your JP? Remember, you will be reporting to the JPA and you'll be doing whatever the JPA has assigned to you. So your vision must be aligned with the vision of the JPA.
Yes.
So that's what I wanted to establish here.
Yes,
The things that you have just outlined to us, that is the problem arising out of the late delay of judgment by the acting judges, the backlog, RAF matters, the pre-trial conferences. Is it part and parcel of the vision of the JP and you share that vision?
Yes, it is.
Okay, and then just my last comment just relates to the manner in which you handled the reopening of the inquest of Dr. Hafaji, and hopefully the mother, although I understand the mother is no more, but
yes,
she would have been able to find closure, because in 1976 when it occurred, then she had a lot of questions, and those
Yes.
questions were never answered until she departed this earth.
Yes.
Okay, thank you.
JP Mlambo.
Judge Ngosi, it's me again.
Yes.
When you acted as DJP, did you have occasion to attend a meeting or chair a meeting of the PEEC?
Yes. I think it was the last meeting of our PEEC. I co-chaired it.
I see.
With my colleague, because I'm the chairman of the court performance committee. So I do need to know what is happening in the magistrates' court as well.
I see. So you co-chaired with your colleague, who's that?
Judge Hendricks.
Oh, okay.
Yeah.
My experience as JP in Gauteng is I always request the national statistics of the finalization of criminal trials. And there's a tracking tool that Department of Correctional Services has regarding awaiting trial detainees. In your meeting, did you have that report?
Yes, we did.
Am I correct that you realize that there's a perennial problem about the finalization of ATD-related trials in the regional courts?
Yes, there is a big problem.
Okay. So I'm asking you as an aspirant leader in the division, what do you think can be done to address that? Because you'd be the second most senior judiciary leader in the province, and you'll be cooperating with the JP to ensure that access to justice in the province is realized. Do you have any ideas how that can be addressed?
I think, as I said, effective and efficient case flow management is the starting point. They must bring reports to explain why there are delays. And if there are problems that the regional court is facing, to put our heads together to see how those problems can be resolved. Otherwise, if not, they're left to account as to why the matters are not being finalized, why time spent in court is low. That should also be explained to the president of the regional court, obviously. But he must then file a report to the PEEC to explain why the statistics are so low. I think one can take it from there, from the reasons that are given as to why the matters take long to be finalized.
Thank you very much. In terms of the perennial problem of the handing down of reserve judgments, or rather, before I go there, just a follow-up to the first one. This view that you're expressing now, is it a view that you hope to discuss, or did you discuss it with the JP after your experience in the PEC?
It is the view that the JP is aware of.
I see.
Yes.
Okay. And then in terms of reserve judgments, how do you think as an aspirant leader we can address this? Because it's a perennial problem. Taking account of the fact that we don't have judgment writing time as judges, you know that.
Yes.
And how do you propose we can deal with this?
Reserve judgments, I think the norms and standards tell us everything we need to know as a judge. Now, the only way to maybe is if judgments are reserved for a longer period, people's names should be made known so that the colleagues would know that you have judgments that we have not delivered. Perhaps after 6 months, then maybe we should remind the judges to finish their judgments and maybe to explain themselves as to why this judgment has still not been delivered.
Yes. Thank you, CJ.
Thank you, JP. I see that there are no more hands. We have reached the end of your interview, Judge Ngosi.
Thank you, CJ.
We thank you for coming here to be interviewed.
Thank you.
All the best. You're excused.
Thank you.
Colleagues, there is an error in our agenda which I picked up only now. It makes no provision for deliberations for this session we've just completed. So I propose that we go into deliberations now because we're running behind schedule, then take lunch thereafter. Any objection to that proposal? No. All right, thank you. Shall we clear the room, please?
Good afternoon, Chief Justice and
Did I pronounce
Commissioners.
your name correctly? It's Treaty.
Indeed, Chief Justice.
Right. How are you?
I'm fine, Chief Justice, under the circumstances. How are you?
I'm fine as well. Thank you.
Thank you, Chief Justice.
You were born in Gofimvaba.
Indeed, Chief Justice.
And in true form of people from that area, you have kept close ties with Hobuli Goduga.
Yes,
That's
indeed.
one of the comments
Yes, I am.
by the professional bodies. That's a good thing. You obtained some of your legal qualifications from the University of Transkei.
Yes, Chief Justice.
AP Proc and LLB.
Yes, Chief Justice.
And then you obtained a Master's of Law from UNISA
Yes, Chief Justice.
in 2004. You had started working as a candidate attorney at the UNITRA Law Clinic
Indeed, Chief Justice.
in 2001.
Indeed.
But once you obtained your articles, you went to work as a professional assistant at the LHR.
Indeed, Chief Justice.
And then, how long were you with the Lawyers for Human Rights?
I was there almost for a year.
Was that in Umtata?
In Umtata, indeed.
All right. And then you moved to KZN.
From Lawyers for Human Rights in Umtata, I moved to Legal Aid Board in Queenstown.
Oh, yes. Where you remained for just over 2 years
Yes, indeed, Chief Justice.
before moving to KwaZulu-Natal.
Yes, indeed.
Legal aid still.
Legal aid still in Umlazi.
And you remained with legal aid until 2008 when you decided to go to the bar.
Indeed.
Right. Is that where you still are?
That is where I am, Chief Justice.
So how many years have you practiced as an advocate?
If my counting is
About
not
16 years?
between 15 and 16 years, Chief Justice.
And you're an attorney for about 6 years?
Indeed, Chief Justice.
Okay. What kind of work have you been exposed to, both as an attorney and advocate?
The kind of work that I have been exposed to as an attorney at Lawyers for Human Rights, initially it was civil work before Lawyers for Human Rights entered into a cooperation agreement with the Legal Aid Board, wherein some of the criminal work that the Legal Aid Board was doing was transferred to Lawyers for Human Rights. Thereupon, I was introduced to criminal work, which I did until all the various stints which I had with offices of the Legal Aid Board, both in the Eastern Cape and in KwaZulu-Natal. So I was doing purely criminal work from the time the cooperation agreement was entered with Lawyers for Human Rights until such time that I left Legal Aid Board in Durban in 2008.
You have acted as a judge both in the Eastern Cape Division of the High Court and in KwaZulu-Natal, where you want to work now permanently.
Indeed, Chief Justice.
How many acting stints did you do in the Eastern Cape?
I had one acting stint in Eastern Cape, which lasted for about 7
month.
weeks.
Just over a month. And what kind of cases did you adjudicate during that brief stint?
I had one criminal case which I presided over when I came there, and which I did not finish. And the JP then allocated civil work to me, which I did in Umtata, in Gqeberha, and in East London.
All right. Then shortly after your acting stint in Mthatha, you were invited to act
Yes.
in this division. You want to join permanently?
Yes, indeed. While I was working there, I was phoned by acting Judge President Madondo to act for the session that was going to begin in 2013.
Mm. And
In 2023. I'm sorry
Yes.
about 2030.
And you went back for another session last year. Well, two sessions, two further sessions last year,
Indeed.
and another this year until June.
In fact, I had 3 sessions in 2023.
Oh, I see. So in all, you have 4 sessions
In all,
in KZN.
I've got 5 sessions in KZN.
5.
I was invited to act for the session which started at the end of July and
Oh, I
ended
see.
sometime in August.
All right. Did you pick up any reserve judgments during your last acting stint?
I have a reserve judgment, Chief Justice.
How many?
It's one reserve judgment. It is one of the matters which I have referred to in my questionnaire.
Yeah, you listed 3. I take it you delivered the other 2.
The other judgments were delivered, but it was listed as a matter which was partly heard. I heard that matter during recess in July and concluded it. It is the one in which I have a reserved judgment. In fact, that judgment is with the researcher, and I got communication from her yesterday that she will be looking at it in the course of this week, going towards next week, and it should be ready for delivery sometime next week.
All right. What kind of work were you exposed to in the KwaZulu-Natal division?
I was exposed both to civil work and criminal work.
And you wrote judgments?
I wrote judgment.
Quite a few.
I wrote about, when I counted, if my count is correct, I wrote about 28 judgments in total, including the judgments in the Eastern Cape. The one that is with the researcher will be the 29th judgment.
Any reported? You've listed 4 reported judgments.
Yes, there are 4 reported judgments, and those mainly are those when I acted in the Eastern Cape.
All right. All right. I'm going to ask Judge President Boyo Hloti to put questions to you, if she has any.
Thank you, Chief Justice. Good afternoon, Advocate Kleti.
Good afternoon, JP.
Yes. How was your acting stints in both Durban and Pietermaritzburg?
I have found them enjoyable, JP. I enjoyed my time mostly in Pietermaritzburg.
Yes. And we can disclose here that you were very reluctant to make yourself available because you're still earning good fees. And as I understand it, you're waiting for the letter to appoint you as senior counsel.
Yes, indeed. I still waiting for my letters, patent. I was very reluctant, but I reflected on the issue, consulted with my family, consulted with my senior colleagues in the profession, and upon reflection, I thought I might as well come when I still have energy and not wait until very late when my contribution might be minimal.
Yes. And I note in your CV that you have a passion for training.
Indeed, I have a passion for training, JP. I think that passion came from the difficulties which I had noted in relation to the time when I was at the University of Transkei, particularly with bookkeeping. Over time, I realized I was doing better than others in that subject. So I took it upon myself to help my fellow classmates. Later, when I had gone to do articles of clerkship with Unitra Law Clinic, I still had that thing in me. Many people approached me. I assisted them. Over time, I realized I might as well do it because clearly a number of people are dependent on me. When I moved over to KZN, I was surprised that it continued to an extent that I remember one colleague of mine who was desperate to pass it. He had failed it 3 times. He came over from Butterworth, lived here in KwaZulu-Natal. I prepared him for bookkeeping, and when it was time for him to go and write board exams, he went over to the Eastern Cape and he reported to me later that he had managed to pass. Unfortunately, for the period in August, I was approached again, but unfortunately, I was working on second. I could not be able to help, but usually, both in the sessions in February and August, I usually assist candidate legal practitioners with bookkeeping.
And I saw that you continued with that. You still do, even though you're no longer an attorney, but
Yes.
an advocate.
Yes, I still do, JP, because I'm a member of the BLA. So by virtue of that, it is my responsibility to ensure that I continue to assist, despite the fact that I may no longer be an attorney, but an advocate.
Yes.
I also was requested by the Society of Advocates of KwaZulu-Natal to assist with tutoring in criminal law and procedure, and I have been doing that since 2021 to date.
Yes, and should we just add voluntarily? You are not getting paid for it.
Insofar as bookkeeping is concerned, I'm doing it voluntarily, but when the bar comes knocking to your door and say, would you be in a position to assist? You usually have to oblige, at least at the level of the bar.
Yes. Then the other thing that you seem to have assisted greatly is the issue of briefing patterns when you were either you are still serving or when you were serving in the bar committee. Can you tell us a bit about that?
Insofar as the question, this is one of the problematic issues which we as the bar, I would say in KZN, are grappling with. It's an issue that we have found there, and we have found people who grappled with, such as the late Advocate Mkhize and Judge TV Norman. When the late Advocate Mkhize passed away and Judge Norman was appointed to the bench, we took it upon ourselves to continue with that, to ensure that those who came late to the bar do not find themselves closing shop and going home. So to that end, I've worked with one of my colleagues in one project in which we introduced juniors to eThekwini municipality. I prefer not to mention the colleague that we pioneered that project where we introduced junior members to the municipality in eThekwini.
Thank you. And in acting in the KZN division, one of the great things that you have done for me as the JP in particular is that you agreed to do a criminal session on circuit in Scottbury, because that usually doesn't happen, that we send acting judges out on circuit, but you happily agreed to do that.
I happily agreed to do it because I have got no difficulties per se presiding over criminal cases. And even if I did, when duty calls, you've got no reason to say no. Even if it was an area of law I was not comfortable with, I was going to be duty bound to do it. But I found it easier to do it. I know the area. I've worked there before when I was working at Umlazi. I know the area well. So it was easy for me to agree to do that stint in Scottbury as an acting judge.
Yes. And I see from your CV, you do quite a lot of matters in the land court.
Indeed, I do quite a substantial portion of matters in that court. Indeed,
Yes.
JP, yes.
So part of the skills that I would imagine, or something that might help that court, and I know that they go through that process, is mediation.
Indeed, it is mediation.
And have you had an opportunity to assist in mediating some of the matters?
No, JP, I haven't had an opportunity to mediate the matters, but it does happen that those matters at some point are so fiercely defended. I would mention a big matter that we had done with was a group of advocates and attorneys. Did it in Melbourne. It was a problematic land claim. That matter was resolved by way of a settlement. It was not tried. So when you deal with the land claims matters, sometimes you find those situations where the landowners are willing to talk, and you engage yourself in that painstaking process of having to negotiate with the landowners, ultimately come up with a settlement.
Yes. To go to the next question, I want to start with this one. Have you ever been found guilty of misconduct by any professional body from the time you started and up to date?
I have not been found of any misconduct.
Yes.
JP.
This then takes me to the objection by, I think, the LSSA about the judgment that we are awaiting at the SCA. But more importantly, the judgment by Khanca AJ. I had an opportunity to read it, and without going to what the SCA might say or not say, what surprised me was the fact that if you want to, perhaps let me rephrase and say, if you want to issue a court order against a legal practitioner, what is the usual way in which we do that?
It is set out in a number of cases, like the case of Black Sash, and many other cases. And we had drawn this to the attention of the court, that the procedure that they sought to adopt was incorrect at two levels, both substantively and procedurally. But despite us drawing that to their attention, we were never listened to. The procedure is that as soon as that order is contemplated, a rule is issued calling upon that particular legal representative to show cause why that particular order should not be granted. That is what we complained about. That if this is the order that you are contemplating, this is the procedure that you should adopt, so that we did not have to find ourselves having to defend the claimants on this side while we have to defend ourselves on the other side. But that was never listened to. We were indicted there, convicted, and sentenced without trial.
Yes. I know that we're waiting for a judgment there, but my understanding from the discussions we had before you even made yourself available was that the one judgment was out and the SCA had, the appeal was upheld. And in your view, in our discussion, it was that that judgment and the one that we're waiting for a judgment from were almost the same in all respects.
Indeed, if I would call these two judgments, Mavundulu and Luhluni judgment, the Luhluni judgment, the SCA deleted that order which related to us for the same reasons we had complained about, that this is not the procedure. If for one reason or another, the order which is contemplated would be justified, then at least the procedure, which is an established procedure, should be followed. The SCA in September of 2021 deleted that order which related to us and found that there was no justifiable reason why that order should have been granted. Now, insofar as the Mavundulu judgment, if one looks at that judgment, particularly paragraph 66, the honorable judge there says, I am bound by the Luhluni judgment. That on its own, once that judgment was set aside insofar as we were concerned, it followed naturally that the Mavundulu judgment, at least insofar as the issue of whether that claim was frivolous and vexatious, it had to take that course too.
Yes. And then I'm not going to ask you about judgments because from the ones that I have seen, I don't have issues. But maybe my final question is, what in your view are the attributes of a good judge? And highlight for me those that you might possess if you have any.
Judge President, there are many, but perhaps I might want to emphasize those that I might bring along with me if I am recommended for appointment. One of those is Ubuntu, it's courtesy, it's patience. A human being has 2 ears, but I recommend that one should be able to bring a third ear, so that in a situation where you are in court, you have formulated a prima facie view on the matter which is before you. You would have enough patience not to listen to 2 ears in terms of the prima facie view which you took, but use the third ear and allow a hearing, even if you have a prima facie view. So those are the attributes that if I were recommended for appointment, I would bring along with me.
Yeah. CJ, I know I said that was my last question, but there's just one more that relates to that complaint again. In the other matter where they say you did not hear it because it sounds as if you ran away from dealing with a matter. That matter, I was in Devon with you when that matter came and more papers were filed. You came to discuss it with me because the other side was ready to proceed, but the other one was not ready to proceed. Maybe you can just tell us briefly what happened there.
What happened in that matter? Hadebe J had granted an interim relief and issued a rule on the 8th of September of 2023. The rule was returnable on the 15th of September 2023, which that date happened to be the date on which I happen to be a duty judge in motion court. A day before the hearing on the 15th, heads of argument came in that matter to my chambers through my registrar. I was reluctant to accept those heads of argument, but I decided against not accepting them. That perhaps there is something that is said in them. I took them, I considered them. The insistence in those heads was that the matter was to proceed. That surprised me because the matter was not allocated as an opposed matter. So when the matter was called, counsel who appeared for the applicant insisted that she wanted the matter to be heard, while counsel for the other side said the matter was not ripe to be heard and it was not set as an opposed matter. So it was not possible that the matter could be heard. So what I did was in motion court has to be fast. I requested the parties to speak and I stood the matter down to enable them to speak and craft an appropriate order. And indeed, I stood the matter down. When the matter was recalled, the parties had crafted the appropriate order, which was to the effect that the matter was going to be adjourned sine die. The respondent was granted leave to supplement its answering affidavit because there were expert reports which were filed by the applicant in the replying affidavit. So I granted them leave to supplement. And then the further order which I granted was one which said they had to approach the senior civil judge for them to allocate them a preference in the matter in view of the fact that it was an urgent matter. But the rule remained in place. I extended the rule until confirmed or discharged because I wanted to preserve the status quo in relation to the matter. I was then surprised to be slapped with a complaint when there is nothing I had done but to follow the practice directives of the division as I know the practice directive 9.1 and 9.2, which are instructive on a matter such as that one.
And the order was by consent?
The order was by consent.
Yes.
JP.
Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you. I don't have a question.
JP Mlambo.
Thank you very much. Good afternoon, Advocate Khiti.
Good afternoon, JP.
Am I correct that when you were at the Mlazi Justice Center, you worked with Mr. Velamdaka?
Indeed. In fact, if I may explain that, at the time I was there, he was the regional operations manager.
Yes.
The person who was there as the Justice Center executive was Miss Zanele, the late Miss Zanele Msweli.
Oh, yes. Thank you. Your acting stints, all of them have not been term long. Am I correct?
Indeed, Judge President.
I just want your opinion. You want to be appointed permanently, but you've never faced a term-long judge's allocation. You don't think that could be an impediment?
Let me predicate my answer, Judge President, and say that it may well have been beneficial if I had acted for the full term, but I hadn't. I am confident that the 30 weeks which I had is sufficient. I have seen enough to be able to deal with the rigors of a judge.
Yeah. On average, this is my last question, CJ, in case I'm criticized. On average, how long has it taken you to hand down your judgment?
It varies, JP, and there are a number of reasons why. Some judgments, the turnaround time would be 2 weeks. Some judgments would be the full turnaround time, which is recognized in terms of norms and standards. But there are judgments where I had exceeded that time period, especially when I came back from the Eastern Cape and was acting here. That would be contributed by a number of factors. For example, there's one judgment which I have attached on my questionnaire, the judgment of Kentep. It took me quite a while to finish that judgment.
Yeah, I think Advocate Triti, let me help you.
Yes.
Cases come with their own dynamics.
Yes.
I think that's what you're trying to explain.
Yes, indeed.
All I want to know is what has been the average in terms of your judgment delivery time. You say sometimes 2 weeks, sometimes 3 months, sometimes longer than 3 months. But what average can we work on? 4 months, 5 months, 3 months?
2 months, JP.
2 months.
Yes.
Thank you very much. Thanks, CJ.
Thank you, JP. Commissioners on the virtual platform, do you have questions for the candidate?
No question from my side, CJ. Thank you.
Commissioner Bredenbach?
No, thank you, Chief Justice, no question.
Thank you. Commissioner Mugaito?
No, I just want to ask Mr. Triti whether the case you were discussing with the president is the case of Case Center versus Freddie and others.
Indeed, Commissioner.
No, so that's your explanation for that issue.
Indeed, Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner Mugaito. All right. Short interview. We have run out of questions for you, Advocate Triti. Thank you for making yourself available, and good luck.
You're
excused.
Thank you, Chief Justice.
Good afternoon, Advocate Harrison.
Good afternoon, Chief Justice.
How are you?
I'm well.
All right. You were born here in Johannesburg.
Yes, I was.
But then you went to study in KwaZulu-Natal. Why did you not study at Wits?
Because my
Or
family
BP?
moved to Durban.
Oh, I see.
And I grew up in Durban.
All right. And you studied BCom and LLB successfully at the University of KwaZulu-Natal. Was that the University of Natal? It would have been the University of Natal back then.
It was UKZN Howard College at
Howard
the time.
College. Yeah. So in Durban.
In Durban, yes.
That's my alma mater too. You started out at the sidebar, was a professional assistant, worked your way up to director partner, and then decided to join the bar after how many years?
After
6 years?
Well, 6 years, including my
Including
article,
articles, yes.
including my articles, yes. 1 year as a professional assistant, and then 3 years as, 3.5 years as a director of DITS Incorporated.
Yeah. And you've practiced as an advocate since 2000?
Yes.
And your areas of interest, as appears from your papers, are the ones the judiciary has particular interest in right now. Not that I'm giving you any hopes or anything. You have a special interest in commercial litigation, and you do insolvency, company, tax, and intellectual property law matters by and large.
Yes, a lot of insolvency and a lot of company law as a result, yes.
Yeah. And you have sat in various insolvency inquiries.
Too many to remember.
Right. And you have been, well, you've done a lot of things for the Society of Advocates of KwaZulu-Natal, which you are currently serving as a secretary.
Yes, I'm honorary secretary at the moment, and I have been lecturing insolvency in KwaZulu-Natal since 2010, because we have some very peculiar local practices in Natal, the way we practice insolvency in the form of our notice of motion and things like that. So it's something that is unique to KwaZulu-Natal, and we tend to preserve it.
Good. And you continue to lecture to date?
I still lecture. I'm still part of the pupillage training. I will be lecturing the pupils within the next month as well, and I have lectured, as I said, since 2010.
Right. Your practice also includes a very thorny area of our law, the road, well, for our courts, road accident fund trials.
Yes.
You've acted for, I count 3 terms, or sessions as they are called in that division.
I have.
How many sessions have you?
We split the sessions into 5-week sessions. So I have served 5-week sessions. So 25 weeks in total.
All right. And what kind of work did you do during those stints?
During those stints, three of the sessions, or 3 of the stints, were in the civil section, and the last 2 stints were in the criminal section, doing criminal law.
You've listed 6 judgments you wrote. Are those the only judgments you wrote?
No. I've written 27 judgments, but a lot of them have come out after the application was put in. So after my application was put in, so since the 1st of August, I've handed down 12 written judgments.
None had been reported at the time you completed this form.
None had been reported.
Any
No.
reported now?
Not at the moment, no.
Okay. All right. No, I'll stop here and allow the Judge President of the division to ask you questions.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Good afternoon, JP.
I understand that you were also recommended for the status of silk, but you still have not received a letter.
That's correct. We've been waiting for quite some time now.
Yes. And when you were acting in the division, how did you find the acting stints?
I had fun. They were enjoyable.
Yes. I don't want to tell the commissioners that we regard you as talking a lot in between the corridors, but that's why you had fun. Just on the insolvency and business rescue matters, indeed, that a very limited number of practitioners have this expertise in that area, and I see that you've practiced in that area for quite some time. Have you done anything to empower other colleagues so that they can be able to understand that area of law?
Well, that's where the lecturing has come in. I lecture a specific lecture on both insolvency and then a separate lecture on business rescue to every pupil, and I've done that for every pupil since 2010. So by my count, it's about 280 pupils since 2010 have been lectured to by me on that, on business rescue, insolvencies and liquidations. In addition to that, in all of my current matters in which I'm currently involved, I either have a junior who is either a woman or a person of color in all of my insolvency matters that I'm currently involved. So that is also part of the empowerment and passing on the knowledge.
Thank you. And I must say that recently I had an opportunity to be invited by Advocate Makola SC. He's now the convener of the trial advocacy, and they had a whole week session training advocates for free. I was quite impressed by what the GCP does in relation to empowering upcoming legal practitioners. Have you ever had an opportunity to be part of those?
Well, I have done Pamula both last year and then I assisted again this year. I also just did the records going back only to 2016, but since 2016, I've been part of the training of 142 pupils at the Durban Bar. And when I say training, I was involved in a training exercise. So I did what we call the method, and I was involved in training all 142 at one stage or another. So yes, I've been involved in that, and I've lectured and presented at Pamula.
And the acting stint relating to criminal law, When had you done criminal law before? Before you did your acting stint? You did a term for criminal session?
Yes, I did.
Yes.
Prior to that, I had done what was in the old days the Prodeos. That was in early 2000, and I'd done a few Prodeos then. And prior to that, when I was still an attorney, I had done 5 or 6 criminal matters.
And are you happy with the work that you did and the judgments that you produced?
Well, yes, I am happy, but I've given leave to appeal on one of the sentences in one of the matters, and that was that's something that I believe that whilst I'm happy with my judgment, the state conceded that they thought there may be a prospect that another court may come to a different decision, and so on that I granted leave to appeal.
Yes. And also during your acting, the one thing that I was particularly happy with, whenever you were done in court, before you reached your chambers, you came and reported that you were done. Is there anything else? And of course, I would give if there was. But that's one thing that was commendable, because people tend not to come and report that they're done, so that you can see if they can assist in any other way. So if you do get recommended, don't change that. Yes. And also the one area that you assisted on as part of the bar, I embarked on a project of doing appeals during recess by the bar. Maybe you can tell how you assisted there.
Well, in my position as honorary secretary, I not only helped to coordinate, but I also found colleagues at the bar who were able to help with criminal appeals. And so what we did over a period of 2 weeks, we organized that members of the bar, and always either people who had acted previously or senior members were then put with previous acting judges, so that we could deal with the backlog of criminal appeals. There were generally 2 criminal courts sitting per day, and with that, there were normally 2 or 3 appeals in each court. So if you do the maths, we dealt with nearly 40, at least 40 criminal appeals during a 2-week period through the assistance of the bar and the bench working together.
Yes. And finally, on my side, Advocate Harrison, and maybe just to mention that because you stay in between Maritzburg and Durban, you did both Maritzburg and Durban, and whenever somebody was not available, you easily stood in for them.
Yes, it's because of the nature of my practice and the insolvency work that I do, appearing in Maritzburg isn't a problem. So yes, it was an easy thing to do.
Yes. I did not see any objections from the professional bodies. They seem to be all complimenting. So the final question from me would be, if recommended, what value would you be bringing to the bench?
I've been a team player in a lot of sports teams, and I think that each one has their own value as part of a team. And I think that as a team player, I would be bringing commercial experience to the team that you're building in the KwaZulu-Natal division.
Thank you, CJ.
Thank you, JP. Do you have questions for the candidate Premier?
No, thank you, CJ. No question.
JP Mlambo.
Good afternoon, Advocate Harrison.
Yes, good afternoon.
Am I correct that you've acted for a total of just over 3 months?
25 weeks, yes.
That's over 3 months.
Yes.
You've not had a term-long acting stint?
The longest session that I spent was this last session, which was I did back-to-back criminal sessions for 10 weeks.
Yeah. And you had 10 weeks acting stint?
Yes.
That's a term-long appointment?
Yes.
Okay. And what's your average turnaround time for reserve judgments?
It all depends. My average turnaround time is normally within 2 or 3 weeks, but there have been two that have taken a bit longer.
Thank you, CJ.
Thank you, JP. Are there questions from the colleagues on the virtual platform?
Yes, CJ, thank you very much. I do have 2 questions. Can I proceed?
Yes, please.
No, thank you very much. Good afternoon, Advocate Harrison. I'm not sure, am I audible?
Just repeat what you said. We didn't quite catch it.
Advocate, but nonetheless, let me just get into the question. The first question that I want to ask you, it is something that I'm happy that you are practicing in the area, and certainly we really need judges who really understand insolvency law. My question is on the thing that is happening in the industry currently. There is a question whether creditors that came after business rescue has been commenced, whether they can participate in a meeting called by the business rescue practitioner to consider the business rescue plan. I'm not really sure if you have seen the debate and what are your views in that respect.
I think that you've highlighted one of the lacunas in the business rescue legislation that has been identified for quite some time. That in insolvency, you have a formal procedure which is recognized under Section 44 of the Insolvency Act in order that claims can be properly registered and dealt with. And this then is a lacuna in the business rescue legislation, because who is to determine what is a creditor? Because what if the debt is disputed? This debate has been going on for quite some time and is generally having been dealt with on a case-by-case basis. For me to express a view as to where it's going to go is something that I think needs to be a development of our law, that we need to develop a mechanism in which creditors' claims can be properly listed and or debated, because bearing in mind that, as I said, Section 44 of the Insolvency Act has very specific provisions on how a claim is proved and how you can interrogate it. So I think we need to develop mechanisms to introduce that into the business rescue field.
Advocate Harrison. Let's forget about the Insolvency Act. We're talking about business rescue in Chapter 6 of the Companies Act.
Yes.
And in that particular chapter, there is a definition of affected persons.
Yes.
And creditors are part of the affected persons. So I'm asking you in that context, these are people that have been declared to be creditors. Now the question is, if they came as post-commencement creditors, are they entitled to participate in a meeting called for the purposes of ascertaining whether the plan should be adopted? This has nothing to do with the Insolvency Act.
No, I accept what you're saying. What I was talking about is that your question is about post-commencement creditors. Post-commencement creditors can only come about if there has been a plan has been put in place. But the point being that if you are a creditor, yes, you are an affected person, and yes, you must be heard. And we've had numerous cases, even in our division, on where creditors have been fighting about the right to be heard in those proceedings. So the answer is yes, we need to develop that area of our law.
Actually, there have been recent developments, but nonetheless, let me leave that question and go to another one. I see a lot of cases, a lot of judgments where people who ought not to be sequestrated are being sequestrated in Zimbabwe. What I want to ask you is, can a trustee bring a sequestration proceedings against a debtor without having first required the debtor to pay the amount? And here I'm taking you back to Section 8 of the Insolvency Act.
Sorry, Section 8 of the Insolvency Act are the deemed acts of insolvency.
Yes, the acts of insolvency are quite correct.
Sorry, I don't understand how you can ask whether a trustee can bring an action based on Section 8. The Section 8 is the deeming provision for deeming a person insolvent in terms of the Insolvency Act.
Okay, let me clarify the question. What I'm asking is, can the trustee bring an application for a sequestration using any of those acts of insolvency as a gateway to someone that they have not required them to make payment of the debt upon which the application is based?
The answer to that is obviously something which has been looked at for quite some time, and going back to the Baden-Horst rule, as to whether the debt is genuinely disputed or not. But if there is a debt and if there is an act of insolvency, then yes, you can bring those proceedings. You can invoke the provisions of Section 8 of the Insolvency Act.
But can that be done when a debt is not yet, or a request has not yet been made that the debt must be satisfied? Can you just go to court on sequestration first?
You would need one of the acts of insolvency first, but generally, demanding the debt, if you look at, for example, Section 8B, that is where you have a nil bono return. You've already demanded that debt and acquired a right to exercise on it.
Let me leave it here, CJ. Thank you very much, CJ.
Thank you, Commissioner.
CJ, with your permission, can I just follow up on this?
Yes.
Because I don't think Advocate Harris is following what the professor says. The professor prefaced his question by saying that he has noted that there are people who are being sequestrated in circumstances where ordinarily they shouldn't be. And before a person could be regarded as insolvent, or the court can declare a person as insolvent, there is factual insolvency, but there is also commercial insolvency. Now, relying on Section 8, which is a deeming provision, there has to be an act of insolvency committed. And the professor is asking, is it possible for a person to be declared insolvent in circumstances where an act of insolvency in either form has not been proven, more especially because no demand would have been made to that debtor?
The problem is that what has been, the way the question has been phrased has conflated sequestrations with liquidations, because commercial insolvency is something which we get under liquidations. That is a separate issue. But to answer the question about can a person be sequestrated, I think you need to go back to looking at the manner in which that sequestration occurred. And I'm very aware that when I lecture on sequestrations, that I remind all the people in KwaZulu-Natal of a very fine judgment in the Joburg division of Castleton versus Stride, which says that you have to have personal service of the papers because you are dealing with you're dealing with a status matter. So that in and unto itself is a protection against sequestrations. As to whether a person can be sequestrated before a demand has been made is entirely dependent upon the factual circumstances and the factual matrix of a case. And it is almost impossible to give a one answer that fits all.
I'm fine, CJ.
Thank you. Commissioner Hassan?
Thank you very much, CJ. Yeah, I'm over here. It's always good just to show you where we are.
Thank you.
Advocate Harrison, I take that both on paper and as you were just demonstrating a few minutes ago, your level of expertise in the field, particularly within commercial law and insolvency insurance, etc. It's interesting then that because you lecture and teach quite often that you haven't published or written any sort of papers, and I noticed that as a gap in your application. So I'm just interested into why that is, and then also you haven't had any reported cases, if I'm correct. That's my first question, CJ.
Okay. If you say reported cases, that is in terms of reported cases where I have been the judge. I have a number of reported cases where I have been involved as counsel. I've got at least 8 reported cases where I've been counsel. But as regards the question on my lecturing and publishing, I think the point that I'd like to make is that when we lecture to the pupils, we're lecturing about the law and its practice within that division. So we are dealing with effectively the historic position and the position of how we apply it in our division. That is not something that lends itself towards publication. As regards publishing, my answer to that is I'm a practicing advocate, I'm not an academic.
CJ, my second question.
Yes, go ahead, Commissioner Hassan.
Thank you. I take the point on the reported cases as counsel, and I did mean actually as an acting judge, which leads me to my second question.
Yes.
We have quite a number of candidates who are appearing before us today, many of whom have acted quite a fair amount. I'll just ask it, do you think that you've acted a sufficient amount of time in order to qualify you to, at this point, be appointed a judge?
The answer to that is yes. And I think the reason I say that is because a substantial part of the practice as a judge is motion court. And I'm not sure if you're aware, but in KwaZulu-Natal, liquidations and sequestrations are heard at the end of the roll. So if I can say that I have sat through motion court extensively over the last 24 years, I can say I have spent more than 10,000 hours in that court listening to all the cases that go beforehand. And as a result, my answer to you is yes, because I think that I have an extensive knowledge and ability in motion court, which is a substantial part of the practice as a judge.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Sorry.
I heard you mention twice the need to develop the law to introduce certain mechanisms in the business rescue process. How do you see that development taking place?
It's going to occur at two levels. One is it's going to occur through the conduct of the business rescue practitioners developing their procedures for it. And secondly, through the courts testing whether those procedures are in fact stand up to scrutiny and are inclusive in incorporating all the creditors' claims.
All right. And then as a judge, if you were to consider a development of the law, of the common law, how would you go about doing that?
Well, first of all, I would hope that I'd have experienced counsel in front of me who would be able to give me good detailed heads of argument. And the way to develop the law is to take pieces of all the different cases that have gone beforehand, and what you then do is you put them together as a composite moving forward.
And where does the Constitution feature in this exercise that you're conducting?
Well, the Constitution would feature in that everybody has the right to be heard, and that everybody has the right to appear before either a court or, in this instance, a quasi-judicial hearing, which a meeting of creditors is in many respects.
Sorry, Chief Justice. I think I want to follow up. You see, because I don't understand now, Advocate Harrison. Because you want to develop the common law, but you are not telling us what is the role of the Constitution in the development of the common law.
Well, all I'm saying is I was asked the question, what is the role of the Constitution in all of this? And the Constitution preserves the right to be heard and the right to be seen. And I'm saying that this is also part of developing the law on business rescue, that you need to develop
I'm not asking you about the role of the Constitution in a hearing. The question of Commissioner Pillay is, what is the role of the Constitution in the development of the common law that you want to develop?
Okay. The role of the Constitution is the right to be heard, the right to be seen, and the right to have your debt or your dispute dealt with in a proper and appropriate fashion.
But have you never heard of Section 39 of the Constitution?
Yes, of course I have.
What does it say about the development of the common law?
We are enjoined to interpret it in accordance with the precepts of the Bill of Rights.
And I'm talking about the development of the common law, not interpretation.
Yes, but that's what I'm saying is exactly what you're saying is that the common law must be developed bearing in mind the precepts of the Constitution.
And the other thing I couldn't understand is the question by Commissioner Hassan. You say that in your CV, I've now looked at your CV, you say you also lecture. She then says, why don't you publish? You say it's because I'm a practitioner. But you are the one who told us that you are a lecturer as well.
Yes, I'm lecturing pupils during the pupillage program. I'm lecturing them as an advocate on the practice of insolvency and liquidations in our division.
Or you train them more like?
Yes, training. Yes, sorry, yes.
No, I understand that. I know what you're saying now.
Sorry, it's done by way of a lecture, but yes, it is training.
Yes, all right. Thank you, Chief Justice.
Advocate Harrison, the reason that I asked is because I picked up from your questionnaire that you've got very limited experience in constitutional and administrative law specifically.
Yes.
I just want to understand from you, do you not see that as an obstacle to you joining the ranks of the judiciary at this stage?
No, I don't. And the reason being, and if I can mention it, I've had there was a recent judgment that I handed down in a matter of Naidu, formerly Padiachi versus Changing Tides. And that dealt with Uniform Rule 46A and the execution against property. And there were constitutional principles involved in that matter, and I saw myself clear to granting a judgment in which I set aside a sale and execution and ordered that the property be returned to the applicant.
And have you written a judgment in a matter involving enforcement of rights, of constitutional rights?
No, I haven't.
And you haven't litigated one either?
No, the only constitutional court matter that I have been involved in was the constitutional case on execution against schools, the Kenmont school case. That's the only constitutional court matter I was involved in.
Thank you, Chief Justice.
Commissioner King?
Thank you, Chief Justice. Advocate Harrison, firstly, I commend you for applying. The bench would be enhanced if you were to have taken silk. And I just wondered whether you had applied for silk, and if you hadn't, what your reason for not applying for silk was.
Okay. I applied for silk in 2023. JP, if I'm not mistaken, my silk was approved by the JP in June last year. And I have been one of those that have been waiting since then for the conferment of silk.
Thank you. That answers the question. If I may, my second question then, going back to the discussion with the other commissioners, in a business rescue situation, and it's not my area of expertise, but my understanding is you've got a statutory regime which is aimed at protecting the rights of various stakeholders. And you can get a lot of intimidation in that environment, I'm sure you're aware. You can get creditors who are secured and unsecured, and some treated in a way that they would consider to be very unfair. And you've got various rights of Audi already built into the process. Now, if you were confronted with an application where you're now going to develop the common law, what sort of values would you be looking to ensure accorded with the constitutional values in that scenario?
The first thing that I would be looking at is protecting the rights of workers, because the employees are normally the ones who suffer the most in these situations. And in doing so, that then also recognizes part of the business rescue, in developing business rescue. For a business rescue to work, you need to have those employees knowing that they are secured, and for them to know that if they work, they will get paid. So the development would be in protecting, would be if I can call it, a ground-up approach. Start with the employees, making sure that they are protected and that their jobs are secured in the business rescue, so that if the business rescue is to go further, the business has the necessary wherewithal to continue with the business rescue plan.
Thank you.
Deputy President Zondi.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Yes, good afternoon.
My question relates to paragraph 6 of your questionnaire. It's page 7 and 8 of the paginated bundle.
Yes.
Now, 6.1, you indicate that you appear in tax court. Now,
Yes.
when you appear in tax court, is it in relation to Tax Administration Act or VAT, or what tax cases do you do?
Currently, I'm involved in both
Okay.
income tax and VAT matters, and I have actually got both income tax and tax matters set down in front of the tax court in November of this year.
And then 6.2 of the questionnaire, you say your practice is about 1% of your practice consists of criminal law. Have you ever appeared in criminal court?
I did previously, as I said, in pro deos,
Okay.
but that 1% is there because within the Insolvency Act from section 135 onwards, you have various criminal sanctions, as well as in terms of the, so you have criminal sanctions for conduct where an insolvent has breached various statutes. And I put that 1% down because I'm involved in advising on that from time to time.
But
not appearing.
Yeah, that's what my question was directed at, to establish whether have you ever represented an accused person in court and run a criminal trial?
Yes, I have, and I've done it in both pro deos, and I did it as an attorney.
Okay, that's great. Thank you. No further questions, CJ.
Thank you, TP. Follow up?
Yes, it's me, Chief Justice. I wanted to ask Advocate Harris, have you attended any judicial skills training course?
I did in January this year. It was a very, very interesting and useful course. In fact, if you look at the judgments that I put forward, one of them was Newport and Nandela. I'd like to think that that judgment was influenced by that course, because after I had done a first draft of that judgment, I went on the course and then completely redrafted the course, redrafted that judgment, because I believed that I wanted to incorporate a lot of the tips and the insights that I'd got from that judicial course in that judgment. So yes, I have been on it. Yes, I found it useful. And there is the product in Newport and Nandela.
Thank you, Chief Justice.
Thank you. We've reached the end of your interview, Advocate Harrison. Thanks for making yourself available. Thank you.
Thank you.
You're excused.
I'm worried about this. I'm worried about this.
He has none.
You said in there.
Oh, good afternoon, Ms. Jigela.
Good afternoon, CJ.
Are you comfortable?
Yes, I am.
right.
Thank you for asking.
Okay. You come from my hometown, Tata.
Yes, CJ.
You were born there.
I was born and bred there,
And
and
you
also worked a little bit at Tata Magistrates Court as a state prosecutor.
yes, and you also obtained your legal qualifications there
Correct, CJ.
at the University of Transkei.
Yes.
A BRS and LLB.
That's correct, CJ.
Okay. You were not in one of my law classes, were you?
CJ, I did not want to say this, but I was one
Which
of your
one?
students in the interpretation of statutes.
Oh my goodness! I hope I did not suck as a teacher.
No,
did you enjoy
didn't.
my classes? Be
No, you
careful how you
didn't.
answer that question.
You didn't, CJ, because I passed that course.
All right. I was very young then. As you've already mentioned, you worked for a spell as a prosecutor in the magistrates court. That was just over 4 years.
Just over 4 years, CJ.
Then you decided to move to KZN.
Then I decided to do pupillage at what was then known as the Transkei Bar.
Or you did it there?
I did it there, yes,
All right.
CJ.
What was your...
My mentor...
They are not called masters now. Your mentor...
My mentor was the late Advocate Nceba Dugada.
So you started practicing as an advocate at the Durban Bar in 2005?
That's correct, CJ.
Okay, so how many years have you been counsel?
CJ, it's about 19 years
About
now.
19 years, it's a long time. And you have done many things in the interim. You have acted as a magistrate for 6 months at the regional court in Durban.
That's correct, CJ.
You have sat in, well, you've been a panel member in a few boards, including the Financial Services Tribunal and the Financial Intelligence Center Appeal Board.
Yes, CJ.
And for how long? From 21 until I see your stints in those ones ended just at the end of September.
At the end of September, yes, CJ.
What exactly did you do there as a panelist?
Well, briefly, CJ, we dealt with the applications for reconsideration of decisions that would be taken by the decision makers, and that would be your ombud, that would be the financial service providers like the banks and the insurance companies, and we also dealt with the appeals.
So when you started acting, you had some quasi-judicial skills, acting as a judge, I mean.
Well, if my memory serves me well, CJ, the appointment to the tribunal, it came after I had started acting. I started acting in
Oh, yes.
2018.
Yes, yes. You acted both in the Eastern Cape and in KwaZulu-Natal.
That is correct, CJ.
When and for how long in each division?
Well, I do not know. I have not separated my acting stints, CJ.
Okay, well,
But-
I'll help you. Your CV says you acted in KwaZulu-Natal for a session. Well, I don't know if it was a full session in 2018 November, between November and December.
CJ, are you looking at my schedule of acting stints?
Oh, you have it?
I have a schedule
All right,
of
can
acting
you
stints.
help me figure that out? I'm trying to determine exactly how long it is that you have acted.
Yes, let me find it.
I counted
Should
just
be
over 10
Annexure
months. I'm
C.
not sure if it's correct.
It should be Annexure C,
It's
page 39.
I have it at page 23 of
Of your bundle.
of the bundle. Yeah.
Yes. So basically, CJ, when I submitted this application, I had 42 weeks of acting. The very first acting stint was in Durban for 5 weeks. It was from the 12th of November to 14th December 2018.
All right.
And then I went to Pietermaritzburg. That was 2019, June 2019. So what I've done, CJ, I've tried to avail myself for acting each year, except for 2023. And then recently at Durban High Court for a full term, which started on 15 April until 21 June. But then after I had submitted my application, I had about 2 weeks of finalizing my part head. I have a criminal part head. So I think I have about 44 weeks of acting.
All right. And what kind of cases did you sit in during these stints? Was it the whole range?
The whole range, CJ, but mostly in the civil court and in motion court. I've done civil trials, I've done opposed applications, I have conducted motion court proceedings, I have sat in the criminal court, I've sat in civil appeals, bail, I beg your pardon, criminal appeals, I have sat with the full bench. I have done reviews, in-chamber reviews, the whole works.
All right. Well, what kind of criminal work? Appeals or trials?
Criminal appeals and trials, CJ.
How many trials?
I have I've completed 2 criminal trials. I am now busy with the 3rd criminal trial, which is the one part head that is reflected in my application.
All right. And the 3 judgments you listed as reserved from May, what is their status?
They were handed down. I don't know if CJ would want me to.
No, that's not necessary. You would still fall within the 6 months.
Yes.
How many judgments did you get to write during your acting stints?
I've counted, CJ, about 50 judgments since I started
50.
acting. 50 since 2018.
Any of them reported?
No, CJ.
No. What kind of a practice have you been running? What kind of work do you do?
Basically, CJ, my practice survives on government work. I get more instructions from the state attorney, and I have a few private clients. Recently, since I've taken Silk, I've been doing a lot of arbitrations. I've chaired arbitrations as well. But with the general state attorney work, I do a lot of
labor court matters, land court matters, lot of civil trials and motion court appearances. I have not been fortunate enough to receive instructions to attend to commercial matters. In my years of practice, I've only had the opportunity of being led by senior counsel on 2 tax matters. That was right at the beginning of my career. So that's basically the nature of my practice, CJ.
Yes. You are senior counsel.
Yes, I am.
Since
CJ.
when?
Since 2021. It's my 4th year now as senior counsel.
You list, well, and the professional bodies as well vouch for you. You've been involved in a number of mentorship programs. You mentor young practitioners at the bar.
That's correct, CJ.
And you do a significant amount of pro bono work as well.
I would say significant in the sense that, CJ, it's not the one that is registered on the pro bono register of advocates, but it's the kind of pro bono work that I would get when I visit home at Mthatha. My mom would have her friends lined up to give me or for me to give to attend to their problems. I've had the benefit of assisting ladies who were selling chickens at on the side of the road at near Mandela Park at Mthatha, where their chickens, their livestock was taken by the metropolis because they did not have permits to trade. So those are the kind of work, pro bono work that I do. It's not the kind that is registered. It would be pro bono work where I assist a security guard at my building who has a labor case, who has a dispute with the employer. So that's the kind of pro bono work that I've been attending to, CJ.
Yes. Well, I'm sure you speak for a whole lot of us. Not anymore now for me, but we've had to assist from church disputes,
Yes.
the sub-headman.
That's the kind of work, CJ.
You've been a member of the Advocates for Transformation since 2005.
That's correct, CJ.
And you chair it now.
Well, my period in office ended on the 19th of September this year. So I've been the chair of Advocates for Transformation in the KwaZulu-Natal region for 2 years.
All right. I'll stop here and hand you over to JP Boyorot for further interrogation.
Thank you. Thank you, CJ.
Thank you, CJ. Good afternoon, Advocate Chikela SC.
Good morning, JP.
Afternoon.
I beg your pardon. Good afternoon, JP.
I understand. I must say, I still feel elated even this day when I come across a senior counsel who is a woman, particularly an African. So you've done us proud as the women of this country.
Thank you, Jane.
And might I say in KZ, and I think you are the 3rd African senior counsel from now Judge Norman, then I'm not sure between you and Advocate Kuzoyo who started.
That's correct, CJ.
I received that prophecy of CJ, but it's JP for now.
JP, thank you so much. Before Judge Norman was elevated to the bench, it was her on top, and then it would be Advocate Kuzwayo and myself. But now my senior in terms of African female silks is Advocate Nomusa Kuzwayo.
Yes. And I was touched by your gesture last year when I started office, yourself as the chairperson of the Advocates for Transformation, and Advocate Mahabir as another woman who was chairing the GCB. You ensured that on the very first day you came to my office and said you were there for me, and in fact, you walked the talk from that day.
Yes, JP, we were driven. We had one mandate, and that was to lead the KZN bar. Advocate Mahabir was the chairman of the bar, elected by AFT. And at the time, I was the chair of AFT. So we both had an obligation of leading together the bar. So that was what was driving us at the time.
The only thing you did not do was to agree to my invite for you to act.
That's correct, JP, because at the time I thought I should focus all my energies in AFT and the leadership of the bar, supporting our chairperson, who was the first African, who was the first Black woman to lead our bar. So I felt that let me for once be selfish and focus on that responsibility alone.
Yes. And I see from your CV you chair the transformation committee of the GCB.
Of the KZN advocates, of my bar, of the KwaZulu-Natal bar.
What does that entail? What do you focus on?
Basically, JP, we have a committee which is called the Skills Transfer and Transformation Committee of the bar. So what we do there, I have a committee of dedicated advocates. So we come up with ideas on how to transfer skills to the junior members of the bar. So what we do, we invite judges, especially from our division, to come and give lectures and give us talks on how to improve our skills as advocates appearing in court on a daily basis. So we've invited judges from the SCA and judges from your division, JP. We've also invited senior counsel and other junior members of the bar who to come and make presentations on certain topics. But in terms of transformation, we realized right at the beginning that most of us do not have an understanding of what transformation is or what is it to transform the bar. So we would organize talks and seminars and would have speakers to talk to us about what it means to transform the bar and to be gender sensitive. So basically that's what we're doing. We tried on a monthly basis to have a talk on a monthly basis, and I would be leading those, not necessarily giving a talk, but I would be organizing those talks, and I would go there and be physically present to make sure that things go well.
And you were part of the team that assisted during the recess to deal with appeals in criminal matters?
Unfortunately, JP, I was not, because I had finished my term of acting and I had set aside 2 weeks, if I'm not mistaken, 2 weeks or a week to attend to my part head. So I was not available to assist in that regard.
And in terms of the, how did you find the acting both in Maritzburg and Devon, and do you have any preferences?
Well, JP, I must say, at the beginning, right at the beginning in 2018, when I was posted at Devon, it was daunting until my first day in motion court. By the time I was in matter number 4 of my role, I had settled comfortably. I was in control of my court. And since then, I had never looked back. I've managed all my court roles. I've managed the work that was allocated to me, and I've enjoyed each and every acting stint. And I've received overwhelming support from the judges in the KZN division and even court staff. So I've found it to be very interesting, JP.
And I'm aware that you attended the aspirant judges training sometime.
Yes, JP, I have. I think it must have been 3 years ago, but I attended the aspirant judges course here in Johannesburg.
How did you find it?
Well, because I had acted for some time, some of the concepts that were introduced there were not new to me, but I benefited a lot in terms of judgment writing and in terms of the posture of a judge, what it means to be a judge inside court and outside court. And I must say I learned new concepts, and I think it was very useful, and perhaps I am able to do what I do better because I've had the benefit of attending that course.
Yes. I have not seen your name on the list of reserved judgment. Does that, how long have you been reserving judgments for?
I don't have a reserved judgment, but...
No, in the ordinary list, we get a list if you've reserved more than 3 months or 6 months in the division.
Yes.
So I just want to check, perhaps the question should be, what's the longest period have you reserved a judgment for?
Yes. JP, I would say the longest period would be 3 months and few days. But recently, all my judgments have been delivered within 1 month or 1 month and few weeks. And I've learned that skill from the work that I do at the Financial Sector Tribunal, because the norm there is that you issue a decision within 1 month of sitting. So I've improved from the 3 months period to at least on average, I would say, 2 months.
Thank you. Thank you, CJ. That will be all. Thank you, JP. Premier?
No, thank you. Chief Justice, no, I have no question.
Thank you. Commissioner Matulu Lepu?
Thank you, Chief Justice. Good afternoon, Advocate Riel.
Good afternoon, Commissioner.
You know, I was quite happy when you said the state attorney gave you work. At least the minister must be proud of one part of the state attorney, that is KZN. But what I wanted to find out, the type of work they actually gave.
Well, at the beginning, Commissioner, at the beginning of my career, we were kept busy with the matters like your matters from the Minister of Police. That would be the damages claims, medical negligence, and then it would be disciplinary hearings where a government employee is involved. Then as I gained experience, then I received more civil trials and motion court work. I must say my practice has been mainly motion court work, well, your civil court applications, both unopposed and opposed. Recently, Commissioner, I've been getting a lot of land claim matters and arbitrations from the state attorney. So they do assign to me work that is of equivalent status to the work of senior counsel. Except for what I've mentioned before, that doesn't entail commercial work.
Thank you. Thank you. At least it's a vast variety of work. Thank you.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Mangena?
Can I just follow up this, unless Commissioner Mangena has a different question?
No, you can follow up.
No, you see, Ms. Chigala, I always have a problem with this thing where somebody says, I don't have commercial work, and then you look at their CV, you find that they sit on the FSP. Because that is commercial work, you see. I don't know, maybe it's an issue of like classification or what. You see, if it had been anyway, let me not be. Because I think if you had a different person sitting where you are and you ask them, do you have any commercial experience? Of course I do. You know, so.
Yeah, we
Perhaps I
know
should-
that kind of person.
Perhaps I should qualify that, Commissioner Ngulaitobi, and you're quite correct. The work that I do, or that I did as a member of the Financial Sector Tribunal, yes, I was appointed because I was a practicing advocate, but I'm sitting there to adjudicate. So the commercial work that I'm referring to would be your normal, usual advocates briefs, where I would be the one who's representing a client in court.
No, I accept that. I'm saying that, you know, so far when I've been listening to you, I get the impression, okay, I don't have commercial experience, but in reality you do.
I do.
Yes,
I confirm.
Yeah.
Yes.
Good afternoon, Advocate.
No, we have another follow-up, Commissioner.
Yes, I'm following up on it. I'm just helping the candidate.
Is yours a follow-up question?
No, but I wanted to start with a follow-up. No, it's fine, CJ.
Then let me allow this follow-up question.
Thank you, Chief Justice. Good afternoon, Advocate Chikela.
Good afternoon, Commissioner.
I've been listening to your answers, Advocate Chikela, and I want to raise an issue with you more for the benefit of the minister than for yours. But I think it's a very stark description of the reality of Black women at the bar. If one had to remove from your growth and development at the bar the state attorney work that you received over the years, what impact would that have had on you?
Wow. I would say a great impact, because throughout my years of practice, I would categorize my practice as have received about 70% of state attorney work. That has enabled me to take my children to school. That has enabled me to get a home for them, pay subscriptions, pay rental. That has enabled me to be considered by my colleagues worthy of silk status. So that's the impact of state attorney work in my practice. I don't know if I've answered your question.
You have,
Commissioner.
Advocate Chikela, and can I say that you're not the only Black woman that has had that experience? Yes. I think that's par for the course for all of us. I want to ask a second question, and that's for you to address the consequence of procurement processes on the part of the state attorney, where they limit new briefs to counsel, including Black women, one every 3 months or one every 4 months. If you can just address that.
It's sad. It's sad, and I know that there have been various attempts to challenge that through the courts of law. But the sad reality of it, and I'm going to speak for my bar, is that it seeks to close the doors completely to baby junior advocates because they do not have experience. One of the factors that you must satisfy, one of the requirements that you must satisfy in the bid documents is the experience in that particular field of law. So they are unable to bid successfully and get briefs. That's the challenge number one. Then the second challenge is that it sort of limits practitioners to specific categories of law. Because if you say in the bidding form that you have an amount of experience in administrative law, you are sure to receive more matters on administrative law and no matters on tax law because of what you've stated in your bid document. But other than that, There are other requirements that you have to provide a certificate of good standing. Some advocates, they are practicing without a certificate of good standing, not because they've been mischievous, but because they have not been able to pay their bar subscriptions. So you are caught between paying bar subscriptions and paying rental, putting fuel in your car, buying food, and taking your children to school. So it's really not a good position for advocates to find themselves in. But I understand that there are processes dealing with that. So I'm not going to go further, just in case I risk saying a lot.
And final question, Advocate Chikela, is notwithstanding all those crippling systemic obstacles to Black women at the bar, you've not only survived, but you've thrived. And the question I have for you is, why in those circumstances do you want to go to the bench and not continue to make your mark at the bar?
Yes. I've been asked this question many a times. I must say, Commissioner, I truly enjoy my life at the bar. I enjoy the work that I do at the bar, the contribution that I make. However, I believe that I can still contribute within the judiciary. I take this as the normal career development or career growth of a practicing advocate. But more than that, I believe with my experience as an advocate, with my skills in litigation, I would be able to contribute meaningfully to the KZN division. Insofar as the charitable work that I do or the transformation programs that I engage in, I can still continue to do that even if I am elevated to the bench. And one way of doing that as a judge is exactly as I had explained, by participating in the skills transfer programs of the bar.
Thank you. Thank you, Chief Justice.
Luckily, we have a Black woman minister who cares about these issues. So we hope she's listening very carefully. And what is heartbreaking, I did not want to say anything about this. What is heartbreaking is that the next generation of Black women advocates is suffering the same challenges I went through 25 years ago in our democracy. So that's what we're dealing with, Minister.
May I follow up, CJ, on
Oh, yes, JP.
Yes, thank you. You're not being candid about also why you're coming. You've survived more than 3 JPs trying to convince you to come to the bench.
Yes.
Yes.
Yes, I've survived more than 3 JPs. And my reason has always been I want to practice as senior counsel. Can I be given an opportunity to live that dream? And then the other reason that I would give was that my children are younger. Until I ran out of reasons, the current JP was counting because I had said I would avail myself when my youngest child is 10 years old. He has turned 10 years old just last week. So I could not, change that. So I am here now.
Thank you, CJ.
Because of that.
CJ, may I ask a follow-up related to this matter? Thank you very much. Advocate, yes, I'm over here.
Oh, yes.
Advocate, just maybe to build on what Commissioner Pillay and maybe the JP and also the CJ spoken to. Apart from having the minister in the room, you also have, I think, 6 or 7 members of parliament in the room as well. And it's not exactly a legal question, but it is one in which there's one role for the minister to, in fact, there's many roles for the minister to play in opening up access. But I'm interested in your thoughts on this side of the table. Do we need to be legislating more to open up the space? Is it a matter of, do you think that's going to help the culture in terms of changing the space? What, from a policymaker's perspective, in your opinion, do you think needs to happen to open up the way for Black women in particular to not only make it, as Advocate or Commissioner Pillay has said, not only survive in the legal fraternity, and I'll say it is a fraternity, it's a club, you're either in or you're out, and what do you think needs to happen for Black women in this country to thrive in the space? Thank you.
Thank you, Commissioner. Perhaps progressive government policies would help. I do not believe that there is a need for legislation to be enacted, because we find ourselves now as advocates in a position where we have to tender and bid and be asked to conform with the provisions of the Public Finance Management Act, something which really does not fit in with the profession of advocates. And I always fear that if the profession is overly legislated, perhaps that would compromise the independence of an advocate. And it's something that we have so far managed to jealously guard against losing the independence of advocates. So I think progressive policy, which should enable Black female advocates, or even just female advocates in general, to access more work and to be paid timeously. And I want to emphasize on the issue of timeous payments of counsel's fees, because most of us, we do get work, but we are not paid on time. So that's what I think would make our lives better. Thank you, Commissioner.
For follow-up, CJ.
Oh, sorry. The voices are disembodied in here. Commissioner Moimang?
Thank you, CJ. Good afternoon, Advocate Gela.
Good afternoon, Commissioner.
Just in terms of the recent publishing of the legal sector code by Minister Paxdow, which was done on the 11th of September this year, which clearly I suspect will have to give this intervention an opportunity by virtue of the fact that for us to be where we are, it needed a litigation. The former Minister Patel was taken to court to ensure that there is a legal sector code in terms of the BEE. Are you of the view that this code will be able to address some of the issues challenges that you have alluded to? Thank you.
Thank you, Commissioner. I have not had the benefit of going through the code, but I had seen it in its draft form when it was circulated amongst practitioners to comment. Though I cannot specifically take you to the specific provisions of the code, but I am aware that there are a few provisions which seeks to address the issue. I'm not so sure if they will sufficiently address the issue, but I believe it's a start towards the correct direction. Thank you, Commissioner.
Thank you, Advocate. Thank you, CJ.
It was me, Chief Justice. They took all the questions.
I'm sorry, I forgot all about you.
Yeah.
Good afternoon, Advocate Jigel.
Good afternoon, Commissioner.
Yeah, all questions have been taken, and I'm glad that you raised the issue of non-timeous processing of payments to advocates, because it is one thing to be allocated work and another to be paid in time. And it doesn't help to get work but not to be paid, because then you are being turned into a slave. So you need to emphasize on that point, and I did not hear you emphasizing adequately on it. But here's my question, and it relates to your children. One is 16, the other is 10. And seated here and looking at you, I asked myself if you have taken time to find out what kind of support is there in the office of the OCJ, particularly to judges, insofar as matters of mental wellness is concerned. Because given the load of the work, you may find yourself in a situation wherein the situation at home is affecting your work, but there is no support that is coming. So have you applied your mind to that aspect as well?
Thank you, Commissioner. To be quite honest, I have not made inquiries as to what programs are there. But I have had several discussions with the current JP regarding my primary role, and that is of being a parent to my children. And I fully understand that she takes that into account in each and every one of her judges, especially those of us who have young children. But more than that, as you would have seen from my CV, I decided right at the beginning of my career that I should start a family. I wanted my children to grow with my practice. And we have developed a system at home where I have support from my immediate family members and from my partner, and who is the father of the children. But more than that, I am not afraid of working long hours or heavy workload. That's what I've been doing all my life as a practicing advocate. And when I started being invited to act. So we have a system in place, but I will make inquiries as to what support is there. But so far, I have not felt the need to seek help in that regard.
Thank you. That's all, CJ.
CJ, may I just allay Commissioner Mangena's fears that when you were appointed, I think your baby was a few months when you were appointed, CJ, as a judge. But when I was appointed...
I fell pregnant on the bench. I was the first judge who ever fell pregnant on the bench in this country.
Yes.
And CJ, the issue is, did you get the support from the system and the administration?
Yeah, so I'm coming to that, to allay your fears. My daughter was 8 years old when I was appointed as a judge, and my son was 6 years old. I've had very understanding judges president, and I dare say I would never do otherwise, particularly for another mother. Thank you.
She would be lucky because she would be joining a judiciary led by a woman, a mother who's experienced exactly what she has, and a judge president who has lived that experience. So
Sorry, Sujay, can I just follow up? Does Commissioner Mangena want to withdraw the question?
No, not at all. It's a system issue. It's a system issue.
It's a very legitimate issue, Commissioner again. I agree. Commissioners, may I just remind you that we still have 3 candidates to interview. So unless a question is absolutely necessary, I ask that we limit ourselves.
Thank you.
We've kept those people waiting for hours now. Commissioner Trolley?
Thank you, Chief Justice. I thought you'd forgotten me like Commissioner Mangena. Advocate Jikela, thanks very much for the opportunity to ask you this question. Having appreciation for what you've told us about being a black woman advocate, and considering the sentiments and comments made by Commissioner Pillay, reinforced by the JP and the CJ in this regard, I see that you had a stint in government employment in KZN, COCTA. Can you tell us about that experience? I see it was short-lived. So you left your practice and went and worked in the government for 6 months and went back. Maybe you could just tell us how that came about and what resulted in the short service.
Thank you, Commissioner Chalup. At the time, I had been doing a lot of local government matters, and I was headhunted by the Department of, by COCTA, KZN, to support them in the unit, which was municipal governance. And at the time, my son was 3 months old, and my office was in Pietermaritzburg. And little did I know that that role required traveling to various municipalities within KwaZulu-Natal. The furthest that I've driven was to the border of Mpumalanga and KwaZulu-Natal. It was a day's trip. I had to drive back home and to be with my son, who was a baby at that time. And in as much as I thought, I could add value to COCTA and in turn gain some experience, because I did not have any intentions of leaving the practice of the bar permanently. It was going to be for a brief period. But unfortunately, I had to choose my family. And for that reason, I resigned within 6 months of being appointed, because there was a lot of traveling. And you would appreciate that, Commissioner, as a practicing advocate, sometimes you don't travel that much, especially when you are a senior junior, not silk. So that was the reason my stint with COCTA was brief.
Commissioner Likhanyan?
Chief Justice, I listened very attentively when you made the remark, I'm persuaded. Thanks very much, Advocate Jikela, for your fortitude and resilience. Thank you so much.
Thank you, Commissioner.
Any questions from the virtual platform?
No.
Commissioner Breitenbach? Thank you, Commissioners. Well, that's it then, Ms. Jikela. We've reached the end of your interview. I just want to express my pride that someone came through these hands, even if it's just in one course, has come as far as you have. Well done. No matter the results of this interview, I'm proud of you.
Thank you so much, today, and thank you for the opportunity.
You're excused.
Thank you.
I decided not to raise anything because
discuss in camera
Before we call the next
before we
candidate.
call the next, yes.
let's do
But it's
that
going to be
quickly.
1 minute.
All right. May we kindly ask the media to please give us a bit of privacy. Yes, this is all the essential. Good afternoon, Mr. Khalil.
Good afternoon, Chief Justice, and good afternoon to all the commissioners and our JP and KZN as well.
How do you feel today? Are you well?
Oh, it was hectic. I hardly slept, had to reflect on a lot of things, and correctly so, I think. And yeah, but it's been really, really hectic. But thank you, I am fine.
All right,
And
good.
yes.
Well, I promise we won't keep you long this afternoon.
Yes.
And we just spoke to you, what was it, 24 hours ago, literally.
Yes.
So we know exactly, we remember vividly exactly who you are.
Yes.
So I'm not going to put anything to you.
Yes.
And I will give JP, the KZN JP and Hey Premier, and any other commissioner who may have a leftover question from yesterday to question you. But it
Yes.
should not take long.
Yes, certainly.
All
Thank
right.
you, Chief Justice.
On that note, JP.
Thank you, CJ. Good afternoon, Mr. Khalil.
Good afternoon, Judge President.
Yes, I watched the interviews yesterday that you were interviewed for
Yes.
yesterday. And you were not recommended for the Eastern Cape for various reasons other than the reason that you have not acted in that division. So I make the point that it was not for that reason only that you are not recommended according to how you fared from what I saw on the interview. There were various lot of concessions that you made about your readiness and ability. Why would you think that would change for KZN?
Sorry, you're saying I made lots of admissions regarding my ability.
Of readiness to becoming a judge?
No, I don't think I made any admissions. The admission that I made was, Judge President, I was asked a question, if I remember correctly, whether as a magistrate, just purely as a magistrate, whether that would prepare you for the High Court. And I indicated, in my view, not. One must have acted in the High Court to understand and appreciate the intensity of the work.
Perhaps to rephrase my question then, it will be, yesterday this body decided not to recommend you for appointment in the Eastern Cape. Myself and the Premier are the only two people that were not there yesterday.
Yes.
Why would you think that would change today?
I would think that if I'm asked questions about the work that I've done, what I've disclosed in my CV, and asked more questions, perhaps that may bring to the fore other factors. But yes, sorry, JP. Yes, just about yesterday, upon reflection of what was discussed yesterday and what I became aware of, which was not known to me at the time when I accepted the nominations for other posts, I would certainly not have accepted that. And what coming from a senior judge like Judge President Mlambo, although he did not provide any prescripts, just listening to his advice, I think it would be unbecoming of me not to have considered that last night and to have reflected upon that. And I think it's a reflection on my character if I did not do that. And I wanted to say to the commissioner, I meant to say it at the end of this interview, but perhaps I could say it now, that I withdraw the acceptance of the nomination for the posts where I have not acted as a judge of the High Court. I understand and appreciate, and I understand that it was not put forward as a criteria by JP Mlambo, but I understand and imagine as a junior judicial officer, if I did not reflect on that, it would reflect very badly on me. So I just wanted to say that I do indeed do so, not because of any pressure, but because of what was discussed, and I understood what was discussed yesterday, particularly relating to being in the High Court in a division where I've not acted.
Sorry, JP, may I just get clarity? Are you saying you are withdrawing your candidature for the position advertised for the Limpopo division?
And Western Cape.
The Western Cape as well. All right. We have noted that. Thank you.
Yes, and I just want to repeat, I do that freely and voluntarily based on what what I learned yesterday, which was not within my knowledge at the time when I accepted the nominations. Thank you.
Thank you, Mr. Karen. Carry on, JP.
Thank you. And lastly, on my side, CJ, Judge President Mlambo brought it to attention that for a person to act or even to be nominated, they get identified by their peers. Your nomination letter is from your ex-boss, if I may say that, the previous.
Yes.
Yes, it sounds like a motivational letter for promotion. How do you compare the two? You know, your peers identifying you for nomination, various advocates or various other magistrates other than your direct boss that would write the motivation for you.
Yes, I take that point, but what I can comment on, JP, is nobody would know you better than your immediate supervisor or boss, as you put it. And it wasn't for the first time that he had nominated me. He's left the profession quite some time. And I do understand, and I've received from the commission comments on my nomination. And I omitted to mention that I thank all the law bodies for having taken the time to have gone through all my judgments, my CV and my history for those two posts and to have made comments on that. For me, initially, JP, I was really happy. You know, when I was shortlisted, when I learned I was shortlisted for so many posts, and in my mind, that served as some confirmation for me that I would not have been shortlisted had the Judicial Service Commission not seen value in me. So I truly appreciate that, and coming from the background that I do come from and all the various comments, it adds a lot of confidence, and I think it can be an example for other magistrates as well, that the way you try to work as hard as possible, minus what I didn't know at the time when I accepted the nomination in other provinces, that you can be given recognition for that.
Thank you, CJ, that's all.
Thank you, JP. Do you have any questions for the candidate, Premier?
CJ, no, thank you very much. I don't have a question.
Thank you, Premier. Commissioner Hassan?
Thank you very much, CJ. Over here, Mr. Khalil, Commissioner Hassan.
Yes, yes.
Some questions I had, and I didn't want to pose them yesterday because we were dealing with the Eastern Cape Division, and today, of course, we're dealing with KwaZulu-Natal, and therefore I want to ask a few questions related to the work that you've done within KZN.
Yes.
If I'm not mistaken, Mr. Khalil, you've dealt with some of the July 2021 unrest and some of the key cases in Phoenix, if I'm correct.
Yes, I have.
Right, so protest, as we know in South Africa, is almost part and parcel of our history, but it's also part and parcel in many ways of our identity as South Africans. It's a right enshrined in the Constitution, etc., etc. But so often it's also the last point of call for our communities, especially young people who tend to be at the forefront of service delivery protests, etc., etc. And we've also witnessed, Mr. Khalil, police who tend to be very heavy-handed and often arrest community members en masse at a protest. So I'm interested in the context of July 2021 and the Phoenix cases as well. For the purposes of conviction, which legal principle would you use to distinguish between a guilty person and those who happen to be exercising their right to protest, and those who are actually guilty of the crime? We know the doctrine of common purpose is quite a controversial one, especially in our history, legally speaking. But I'm very interested to know what legal considerations go in, because you've dealt with some of these cases, between those who are guilty and those who are just at the protest. Thank you.
Thank you. I don't think it happened, Commissioner, in the context of a protest. There was large-scale looting, as we all saw it on television. There was a large scale of violence, and I dealt with the matter in the context that certain alleged perpetrators were arrested, and it was at the time where the police were largely absent or even overwhelmed. And a lot of I think if I remember correctly, there were 38 murders in Phoenix. And the army was at our courts, just to give you the context of those matters. The reason why I dealt with those matters is some of the other magistrates that I allocated the matter, or I intended to allocate the matter, were afraid. They had family living in Phoenix and friends. So as the acting chief magistrate, and I've done it on many other occasions, I had to lead from the front, and I think I spent almost 2 months just dealing with those matters, and in a lot of those matters it was mainly senior counsel. So that is the context in which I presided over those matters, or quite a number of those matters. And it was really hectic. And the one matter you asked me about, it is a matter where I had refused bail, because the finding I made on a prima facie level, and after having watched, it's not often in a bail application where you have the opportunity to actually watch exactly what had transpired. And there was a very senior counsel in the country that I think came out of retirement. He did the matter, but in any event, he withdrew. But when I saw that video, it causes you to go home, you cry, you ask, but what motivated other human beings to act in the barbaric manner that they acted? And the finding that I made was on the basis of common purpose on a prima facie level. I accepted that the state had a strong case. I refused bail on various grounds. It's like a 52-page judgment. And the one finding I did make was that the attacks, in my view, in terms of the evidence, were racially or based on racial profiling. That is the number of cases that I made. The other difficulty was that in so many of these matters, lots of the suspects were allegedly assaulted in prison. They were not given sufficient food. They were robbed. And it was so many dynamics in those matters that I eventually had to take the course of having the head of the Correctional Services subpoenaed to court to deal with that, to deal with those issues. But the short answer is that in exceptional circumstances in the bail legislation, and I found these to be exceptional circumstances where it would cause public outrage, where it invokes a lot of, basically outrage and public disorder. And because of the strong prima facie evidence, in my view, and I use the one leg of the bail legislation, which says only in exceptional circumstances may you do so. It's been referred to as the Lynch law or so, but I thought it best, after having considered all the evidence, that there were no exceptional circumstances which justified the release of the applicants on bail. So it was really hectic, but it's fine. I mean, we all deal with these types of matters. But during that period, we've had magistrates being disallowed to come to court on public roads, the senior magistrates, couple of them. And they asked me for, at that time, if you remember, during COVID-19, you have the COVID permits that were issued. I discussed it with them and I said, I find it unacceptable to give any magistrate a permit to come, because you need a permit to travel on a public road in South Africa. And these were two senior African magistrates. They understood it, toughened them up, etc. as well. And there were no problems. But it was hectic psychologically, emotionally. I've never ever presided over matters like those matters.
Sorry, Chief Justice. If I could, I know the agreement, but sometimes you sort of try to help. I think the question is, what is the legal principle to distinguish the guilty from the not guilty? Because so far you've identified common purpose. Common purpose expands the net of the people that are responsible beyond those that can be immediately identified.
Yes.
And it's controversial from as far as Safatsa. The question is, how do you distinguish the guilty from the not guilty? We have a mass uprising, a mass looting. You don't know who was looting, who was not looting. The police have just arrested 1,000 people.
Thank you, Commissioner. Can I just say that perhaps I should have indicated this, that in quite a number of the matters, it was based on a Schedule 6, what we commonly refer to as the Schedule 6 bail application, where the onus is on the applicants. The applicants procedurally started first by handing in affidavits and saying exactly what you have suggested, that there was looting, etc. But from the videos that we watched in court, there was no such looting. For example, you just find 4 youngsters walking on the road, and suddenly a whole group of people come in a bakkie, all armed, and start attacking the 4 youngsters. They run, they come out of where, or they weeded out, and then a continuous stabbing by one person, then another person, then a gunshot to the face. It was in that context, I'm saying, it wasn't as if there was a protest and there were certain people and others were just hanging around. It was an attack on persons who were just walking unarmed, no evidence of any looting, nothing at all. So I used a common purpose on a prima facie level to say that even though one person may not have stabbed the deceased, for example, in one of the cases, but the others by helping to weed them out, the others by perhaps maybe shooting them or shooting one person, the others by assaulting them or blocking their way. So it is on that basis that I made the prima facie finding. So it wasn't in the context that people were looting and others were just standing by and where the police arrested them.
CJ, just my second question. I'm not going to berate the point on the legal principles. But Mr. Khalil, you've also presided over a number of equality cases, particularly those that have been constitutional in nature, dealing with racism in social media, which has been quite interesting given, of course, we're seeing a lot more proliferation of hateful content online. And I think some of your findings have gone quite a long way in demonstrating that there's no place in a democratic South Africa for racism, of course, but particularly also for racism as they are in social media posts. I mean, the Penny Sparrow case, if I'm correct, you presided over or participated in some shape or form. And that's, of course, changed society. And just before I ask my question, it's related. It's also an example of how powerful progressive judgments can be and the kinds of messages it can send to society, that there are consequences for this kind of behavior. So, Mr. Khalil, I'm interested in how long you've been a chief magistrate and how long you acted as a judge and how you think that this has prepared you for a potential seat on the bench. Thank you.
Thank you. For the past 21 years, I think I've been a magistrate. And out of the 21 years, 15 of those years have been in management at the lower court level, at the magistrates court level. I've acted as chief magistrate at Pietermaritzburg for a few months. I've acted at Durban, and currently I'm acting for almost 7 years at Verulam. That post has not been advertised because of the relocation of that post to the far northern areas of KwaZulu-Natal. areas like Umzinyathi, Umzimkhulu, uh, Zululand, they don't have a chief magistrate there that is close to those courts. So it has been decided that that post will be relocated and in the process. So it's for almost 7 years I've been an acting chief magistrate. The equality court cases, yes, the most recent one I've done is on albinism in South Africa, and that's a huge problem. You know, we see these matters on the media, and it was quite a taxing case. And with respect and the greatest humility, I didn't submit that judgment because I delivered it after the acceptance of the nomination and the completion of the questionnaire. But you're correct in that in all the equality court matters, you're dealing with constitutional rights. You're weighing up one right against the other rights. You're contextualizing the disputes in order to arrive at a fair and just conclusion. These matters as well, it puts you under a lot of pressure because of the findings you make and your judgment. Like in the Phoenix unrest-related cases, I was advised by security not to go into the Phoenix area for almost a year and a half after I finalized these matters. So I think it has prepared me quite a bit, especially the Equality Court, because the Equality Court has a very similar powers to the High Court in the sense that you may grant prohibitory interdicts, you may grant declaratory orders, you have the option of getting progress reports on the various orders that you do indeed make. So, for example, if you tell somebody or you order them or direct them to apologize, you direct them to put up a video, for example, to apologize in the same way in which the initial video caused the complaint. You can ask them to do so by a certain date for them to file in all these progress reports, because it's well and good giving the orders, but for the orders to have meaningful effect, I think you have to have these progress reports. So I think all these matters, just very briefly, has given me a lot of experience, and it has opened up my insight. And if one looks at the comments made by the various bodies on my judgments, I did say initially I thank them because it gives you so much of confidence that others would have looked at your judgments and they would have made various comments on your judgment and going through that.
Thank you, CJ.
Thank you, Mr. Khalil. Thank you for returning today. You're excused.
Yes, thank you very much, Chief Justice, and thank you to all the commissioners. I appreciate the opportunity. Chief Justice, I will write formally to the Secretary of the JSC.
No, you need not do that.
Oh, I need not.
She's right here. You are on record.
Okay.
This is what you did is far better than a letter that may get lost in the mail.
Certainly. Thank you very much once again.
Thank you.
I thank you.
Right?
Yeah.
Oh, there's it.
Good afternoon, Mr. Pickman.
Good afternoon, CJ.
Did I pronounce your name
Yes, you
correctly?
did.
Okay. How are you?
I'm okay, thank you.
You look quite nervous, don't be.
It's been a long
relax.
day.
You state that you have 2 degrees, a BA and LLB, acquired from the University of KwaZulu-Natal.
Yes.
I just got curious in regard to your LLB degree.
Yes.
You mentioned that you were assisted financially by the Department of Justice,
Yes.
but at the same time you say your father had been a successful and well-respected advocate. Why
Yes.
would you have needed to be financially assisted by government?
I think that one of the reasons was that I grew up in a family which encouraged you to make your own way. So that was, so for my BA, I got a bank loan. And for my LLB, I got a bursary. And I worked, interestingly enough, in a butchery on weekends as a student job.
But then your dad died tragically.
He died while I was writing my last LLB exam.
Sorry, that's terrible.
At that stage, I was a member of the SRC, and I came out of that last exam to the SRC secretary and a couple of the members there to tell me the sad news. But my parents had been divorced for many years, so I hadn't lived my whole life with him. But after starting to study law, which was his profession, career, our bond became a lot stronger. And then he'd also been involved in politics, and we'd had a connection there. So at least when he died, we had restored some sort of good family relationship.
Yes, sorry for your loss.
Thank you.
So after your studies, you were the department. Well, you owed it. They snapped you up, put you in a position of public prosecutor. But you spent the first 2 years in military service.
So what happened was that because of the bursary, I had to report to the Durban Magistrates Courts on the 1st of December, I think, of the year that I finished my LLB. And I then was employed formally as a prosecutor from that moment. But at the end of December, I was put in a cattle truck and sent off to Pretoria.
And you were there for 2 years?
And I was in Pretoria for what they called a junior leadership course, which was a section of the army that utilized varsity graduates. I became a law officer and then ended up spending the last 14 months in a town called De Aar, which is in the Northern Cape, as the law officer.
What did the law officer do?
It was an ammunition depot. I think it still is. It had a contingent of guards from all over the country who would come every month. A whole lot of guards would come and sit in those towers surrounding the ammunition depot itself, which, interestingly enough, is situated in an extinct meteor crater, which gives it natural protection all around the ammunition depot. And then there are these guard towers. And what we would have to deal with was guards shooting each other, guards driving vehicles into having accidents in vehicles. There was a constant stream of issues that the law officers had to deal with, the law officer, myself. That involved, if it involved a court-martial, it involved catching the train to Pretoria, which was called the milk train, because it picked up milk at every farm that it passed. So the train trip was literally hours, all night and all the next day.
So when you finished your national service, you went back to the department and actually started practicing as a prosecutor?
Yes, I was contractually bound to do that. I was paid as a public prosecutor while I was doing national service. So my contract with the department was in a 4-year contract, the 2 years of the bursary and the 2 years of being an employee whilst doing national service.
So when you completed that contract, you went into the magistracy in 1990?
Yes.
That was not part of the contract now?
No. I did the 4 years that I was contractually required to do. It was just over 4 years, actually. District court and then regional court prosecuting. And I enjoyed the environment. I enjoyed litigation as a trial lawyer. I always have. And I thought it would be in my interests to gain experience presiding, bearing in mind this was all criminal work that I was involved in. Presiding in the criminal courts, and in those days the chief magistrate could just appoint you. And I then volunteered to stay on for another 4 years presiding as a magistrate in the district courts.
Until you decided in 1994 to go and do your pupillage and join the bar?
I had always wanted to, Chief Justice, be an advocate. I wanted to honour the memory of my father. That's why I had done it. I knew I was going to go eventually. And that was the point that was the most sensible for me to make the move.
And you've been a member of the KwaZulu-Natal Society of Advocates for the past 30 years?
Yes.
Doing what kind of work?
Chief Justice, I have varied practice. As I say, I consider myself primarily to be a litigating advocate. And I have had a practice which covers everything from representing people in crime for the first, obviously, 4 or 5 years of my time at the bar. Because of my history in the criminal section, I got a lot of criminal work. So I did a lot of criminal cases. And then I made a point of slowly moving away from that into the commercial and allied field of advocacy. And I've done everything from small helping people with state agency claims to very high profile commercial matters. It's a real variety. I have not specialized in anything.
Do you have are there any judgments, reported judgments, that is, in matters in which you appeared as counsel that you know of?
Yes, there are.
About how many in estimate? Or if you have the exact number?
At least, I think some of them I've mentioned in the judgments which talk about where I acted in cases that I thought were significant in my questionnaire.
No, I mean as an advocate.
Yes, no, I'm talking about.
So
So I answered questions there about cases that were significant while I was an advocate. And most of those were reported. But there must be 30 or more.
All right. And when did you start acting as a judge?
I was first asked to act as a judge in 2020 by Kruger J, who was the acting DJP at the time, I think, for a 5-week stint. He asked me again a year or so later for a 5-week stint. And then I think about last November 2023, through till about 3 weeks ago, I've done a lot of more acting stints.
Okay, so it's 10 weeks plus 3 sessions.
It was 30 weeks, I think, when I did my application. It's now 35 weeks. 35 or 36. 35 or 36. Now, I stopped a stint 2 weeks ago.
Oh, I see. And what kind of cases were you allocated?
So the JP kindly gave me some time in the criminal section just so that I could see the difference between what it was like to preside in the magistrates' courts and what it was like to preside in the criminal high court. I did a couple of sessions there, maybe 3 by now, 1 in Maritzburg, a couple in Durban, I think, at least 1 in Durban. And for the rest of the time, it's been the civil section. And what happens in the KZN division, both courts, is that when you serve for a session, you get at least one motion court per week. You get, in all likelihood, a full court appeal, one. But if not a full court appeal, you definitely will get at least 1 or 2 or 3 or 4 full bench appeals. For the rest of the time, you are on call to do trials. So for all of the sessions that I've acted, CJ, it's been everything. Motion court. I've just done the first week of recess in Pietermaritzburg, where I did 3 motion court days out of the 5, which covers everything. Trial work, whatever is handed to me, I do have done from commercial to RAF, and as I say, the either full court or full bench appeals.
Right. What would you say, well, how many judgments have you produced as an acting judge?
I don't have the exact figure, but I'd say about 26 or 27.
All right. Any of them reported?
No, they're not. They're not reported in the South African law reports or the LexisNexis reports, but they're all on SAFLI.
SAFLI, yes. No, I mean.
So they're published but not reported.
Yeah, that is a difference.
Yes.
Yeah. Okay.
Maybe I should add, CJ, at this stage that I set out in my application that there was one of my judgments had gone on appeal. And when I did the application, the result was not yet known. That judgment, the appeal judgment, it was a full court in Pietermaritzburg. I had refused leave to appeal to the Durban municipality on a 30 million rand judgment. I had refused leave to appeal. The SCA granted leave to appeal. That was heard by 3 judges in KZN, and that judgment was handed down on Monday, and the appeal was dismissed. So, to be honest, I'm proud of that judgment.
Yeah, we know the feeling.
Yeah.
That's a good one. All right. All right. I will hand over to the JP to put any questions she may have for you.
Thank you, CJ. Good afternoon, Advocate Pittman.
Hello, JP.
How were your acting stints, both in Maritzburg and Durban? And do you have any preference of the 2 courts?
JP, I really enjoyed my acting stints. I enjoyed both of the courts. I said at the beginning, I may have even mentioned it to you, that I will go wherever you want me to go if I get the job. I live in Westville. I can drive to Maritzburg or I can act in Durban. Whatever is needed of me, I will do. I did enjoy Pietermaritzburg. It's the provincial division. It's a beautiful old historic building. And I enjoyed the collegiality of the place.
Yes, and I noticed that in your application, you have been nominated by 2 senior council women members of the bar, and I think she's senior junior advocate Noko, and it's quite a diverse group.
Yes.
Is that some reflection on you?
I hope it's a good reflection. Annandale SC is someone I've known since my prosecuting days. I think she is an exceptionally bright advocate and someone whose opinion I have always held in very high regard. Gabriel SC has been a friend of mine since she started as an advocate, as she sets out in her letter, and I've always valued her friendship. She's also an exceptionally talented intellectual advocate, in my view. Nono Nako is an advocate who I have known. She was the registrar of the High Court in Durban, struggled her way through that, getting a law degree, and became a friend of mine when I helped ensure that she got a position in our group of advocates.
And I understand you introduced a nursery in your group of advocates. How did that come about?
Okay, so what happened there is my group of advocates has chambers in Mshlonga Rocks. It has an upstairs and a downstairs, and there are about 20 of us. It used to be in town in Salmon Grove Chambers, but the point I'm making is that we've been together, most of the senior advocates, for a long, long time. Since COVID, it's become, I just became very aware of the fact that it was becoming more and more difficult for junior, previously disadvantaged advocates especially, to be able to afford the kinds of rentals that these institutions were starting to charge for the buildings where chambers were situated. And what I thought was, because a lot of people gave up practice as a result of COVID, and chambers became available, what I thought was, an idea I had was to divide one of the chambers up into at least 4 to enable juniors, and my focus was on previously disadvantaged juniors, to make it more affordable for them. And that's what we're doing, and that's what's working. And we've only had previously disadvantaged juniors.
Yes. The next one relates to your age. You will be turning 64 in a few weeks' time.
Yes.
And I must commend you that I have not felt your age in relation to your industriousness. You have worked hard, probably exceeded some of the younger colleagues.
Thank you.
The question that then relates to that, there are 2 actually. One is, will you have difficulties in respecting, in the judiciary and in the legal profession, the hierarchy is a big thing, the seniority. So now we will have a situation where you are 64 years old and you might have a judge who is 49 years old, who is your senior because she's been appointed before you. Will you have any problem in respecting that seniority?
Thank you for that question. And I'm going to answer it directly, but I'm also going to say that in answering it, I may touch slightly on what I will say when someone eventually asks me why I haven't taken silk, which I'm sure is coming.
I stopped myself from asking that question.
Yes. And that is that I grew up in a family where status was irrelevant as an attribute of a good human being. I have the personal philosophy that I'm better than no one and no one is better than me. My philosophy is that we are equal, whether you are a child or a 20-year-old advocate or anybody else, or a nurse in a hospital or anywhere else. I will have and that's how I've lived my life. I will have absolutely no problem deferring to someone who is younger than me. Maybe I should just mention something else at this point, which is interesting. I know that I said to myself I wasn't going to give long answers, I was going to give short answers in this interview, but I'm going to do it anyway. So I'm a self-deprecating person, I know that. I don't blow my own trumpet, I don't like it, I've never been good at it. If I have to do it today, I'll do it, but it doesn't come naturally to me. I went, at your request, to do the aspirant judges course in June. And people who had done it before me, who I spoke to, said to me, "No, you've been practicing for so long, you're not going to learn nothing. Go, but you won't learn anything." I found, I said this to you, I found the absolute opposite. I loved every minute of it. I thought it was brilliantly put on. It was professional. Justice Matopo, who ran it, was outstanding. The quality of the judges who came to talk to us and gave up their own free time, their own time for free when they could have been and should have been writing judgments, was exceptional. And I learned things that I didn't know. had not known before. And it struck me at that moment that no matter how good I think I may be, there's always an opportunity to learn. And I learned there. And if you ever ask me to go on an aspirant judge's course again, or another kind of judge's course, I will leap at the opportunity. I think I've strayed far from the question.
Yes. So the short answer I wanted was whether you would respect those younger colleagues. Yes. Now, the other question relating to age is we have circuit courts, Madadeni, Pongola, Ofra had, that far. And recently I've had one or two colleagues who are about 67, 66 say to me, and they are quite junior, I must mention, say to me, JP, you must consider not sending us to circuit because of age. And I said to them, you are junior, you will go, you have to do your time. Now you are 64, will you have a problem? And this goes in hand with another question where we have younger judges that have smaller children who might not be able to go on circuit because of those needs. Would you have a difficulty in doing circuits even more often than not in certain instances?
No difficulty whatsoever. I am at a stage of my life on a personal level where my children are finally grown up, out the house. Obviously I've discussed this with my wife, this kind of possibility. It's something I did as a public prosecutor, circuits. I have absolutely no problem whatsoever. In fact, I would suggest that someone like myself is more suited to go and do something like that than someone with young children who needs mom to be at home.
Yes. I'm not going to go so much on judgments and your knowledge of the law because I think it's quite clear from the CV that you are quite knowledgeable and because of the number of years on the bench. But there are just two other aspects I want to canvass. And one is relating to the objection about your temperament. What do you believe in your view are good attributes for a judge?
Well, first of all, I have responded to the temperament allegations in full in writing, and I hope at least that the Commission has had a look at those. I'm obviously happy to deal with any further if necessary. Good. I think that, right, integrity is, I think, the most important attribute, and I have it. I do not lie. I cannot tell lies. I hate liars. The second thing is empathy. I think a judge has to have empathy. As a judge, you're not just sitting dispensing judgments in relation to disputes. You're also managing courts, and you're managing witnesses, and you're managing lawyers. And those people often come from very, very different cultural or other kinds of backgrounds. Empathy means the ability to stand in someone else's shoes. So I think it's a very important attribute, and I believe I have it. There are a lot of things that are needed of a judge: patience, calmness. But the last thing that I think the three things that I'm mentioning, the two I've mentioned already, and the third one is a work ethic. I can honestly say, as I sit here now, that I have never worked as hard as I have while I've been acting as a judge. Never in my practice as an advocate have I had to work as hard as I have to keep up to date with the stuff that you and the division has given me to do. So, and I could do it because I have a work ethic which doesn't allow me not to do it. Now I'm going to blow my trumpet. I have for 30 years woken up at 5 o'clock every morning. I get to my chambers, or if I'm an acting judge, to my office by 6, or 6, if it's in Maritzburg, 6:30, and I then work. And if you have a look at the judgments I've attached to this bundle of documents, you'll see that my turnover rate is about 2 or 3 weeks for a judgment, no matter how complicated, and some of these judgments were complicated. And that's because of work ethic. So I think those are the attributes of a judge. Or I think the essential attributes of a judge.
Yes. And then finally, Advocate Pittman, there is that complaint about you probably not having read papers in that eviction matter.
Yes, it wasn't. It was actually a demolition matter.
Demolition, yes. And in fact, I was quite shocked because I had not received any complaint whilst you were acting as a judge in relation to what you dealt with in court.
That complaint had a number of factual inaccuracies. I'm not sure of the motive for the complaint, but the factual inaccuracies are dealt with in my response. It was not a case of two parties being there. It was a case of one party, the advocate representing the relevant municipality, asking to demolish a building that had been built by the owner, an indigent owner, in circumstances where there had been no personal service on the owner. And in my oversight role, as I said in my response, I was not going to grant a demolition order without knowing that the owner was aware that the application was before court. I had read the papers. I picked that up before the matter was called. It wasn't brought to my attention by the council involved. It ought to have been brought to my attention before I picked it up. But that council was very upset that they didn't get their demolition order.
Thank you, CJ. That will be all.
Thank you, JP. Premier?
Thank you very much. I think it's good afternoon.
Good afternoon, Premier.
Yeah, CJ, I will start with a follow-up question because I had a presentation or a reflection that he believes in himself to be better and no one is better than himself. My question would be then from that one, what's your relationship with your colleagues at work when you believe that no one can match you? You are better than almost everyone.
Yes, the philosophy is in the context of being a human being, not necessarily in the context of the job. As a human being, I'm no better than any other human being, and no other human being is better than me. My relationship with my colleagues is excellent. I've always had an excellent collegial relationship with everybody that I work with.
No, thank you, CJ. I will save the second question, the question, because it was related to the presentation.
Thank you, Premier. Any questions for Commissioner Mtweni?
Good afternoon, Advocate.
Good afternoon, Commissioner.
Advocate, how do you perceive the role of technology in modernizing court processes? And what specific measures would you advocate for to enhance judicial efficiency?
I think that's an excellent question to ask a KZN advocate. And the reason why I say that is this. Although I'm a KZN advocate, I have done work in Gauteng. Gauteng has a system called case lines. It is brilliant. It saves trees because it gets rid of the need for paper all the time. So it's a green project. But not only that, it's just absolutely, it works in such a way that everybody who's a party to the litigation is kept up to date about every single thing that happens in that litigation the moment it happens. This is my impression anyway that I've had as a KZN advocate. Perhaps there are counsel from Gauteng who might not agree with me and might have had other experiences. But my experience in the cases that I've had there is that technology is technology that should be used in all of our courts. We, at the moment in KZN, we work with khaki-colored folders of documents. And sometimes you can be presented with a folder of documents that is 3 or 4 feet high, and you have an obligation to go through it. It's not properly paginated or indexed by the plaintiff's attorneys or the applicant's attorneys. You're trying to find out what the case is all about or why it's in your court in the first instance. I think the technology issue, the technology that Gauteng has, would be beneficial to all of the divisions. So I think that's a good question, and I support it 100%.
No, thank you very much. No further questions, CJ. Thanks.
Thank you, Commissioner. Commissioner Wayman?
Thank you, Chief Justice. Good afternoon, Advocate Whitman.
Good afternoon, Commissioner.
Just one question from my
Yes.
side. I get a sense that you take pride in your period of military conscription.
I beg your pardon that I did that.
You take pride in your service under compulsory military conscription.
No, I don't take pride in it. I don't take any pride in it.
But how you took us through your DR, therefore, that's the impression that you created to me. So the question that I want to pose to you is, at that time, there was a structure called a conscription committee, which obviously was a conscious effort on the part of young white males who resisted the compulsory military conscription, which obviously I think create doubts in our mind as to your conscience at that time. You did not see it necessary. Didn't you see it necessary to join your fellow colleagues who were part and parcel of the end conscription campaign?
Well, thank you.
Well,
Thank you, Commissioner.
Before the candidate answers the question, I just want to place on record that I did not get any impression that he was deriving any joy from the account he was giving me and all of us. He was just, I felt that he was just taking us through a life experience, matter of factly. But go ahead.
Thank you. I think I would like to answer it.
No, do answer it.
I was at university and a member of an SRC that was a left-wing SRC, and amongst the institutions that we had contact with was the end conscription campaign. I tried to stretch my university degree out as long as I could to avoid military service. Personally, I was an opponent of apartheid and did not want to do military service. Eventually, I couldn't stretch it out any longer, and the choices for me were to peacefully object and get, as I recall at the time, a 6-year jail sentence, or go and do it and get it over with. I wasn't brave enough to take the jail sentence, and I'm sorry about that till today, but I wasn't. And I went and did service and got it over with. I was not in active service. I did my basic training in Pretoria at Fort Rekohoogte. At the time I was there were riots somewhere in South Africa, and they came to our bungalow and asked for volunteers to go and help quell riots. Myself and other left-wing members who had been at university with me refused to take part. We refused to go with the rest of them to quell these riots. We sat there. We were treated like rubbish from that moment onwards. That was the best we could do. It was a difficult time with difficult decisions.
No, thank you. I appreciate the fact that we are part of NUSA's activities. Thank you, CJ. Thank you, Advocate Whitman.
Thank you, Commissioner Muiman. Commissioner Nkaito.
Advocate Pittman, two of the objections have already been put to you.
Yes.
But there is one that has not been put by Dr. Ghani.
Yes.
Who says that she was once your client.
It's a man, yes.
He was once a client. Yes. And then appeared in another case now as a litigant before you. But you failed to disclose that fact and to recuse yourself.
That's what he says.
Yes.
So
Well, I don't know if it has been brought to your attention.
yes.
Oh, yes, all right.
I did
You
respond
can answer
to
it then.
I did respond to
Yeah,
it.
no, we've
Yes.
got your response. Just answer for the benefit of everyone.
Do you want me to say anything more about it?
Yes, that's the objection. So
Thank
it says we must ask you about whether
I
you're
see, yes,
suitable
yes.
for judicial appointment, given that this was your client, they appeared before you, you don't disclose, you don't recuse. I mean, obviously you found against him.
No.
Oh, you didn't? Okay, well, still there was a duty of recusal. But anyway, what do you say?
So thank you, Commissioner. So he says in the complaint that he was my client in 2018. I can't remember that he was my client in 2018. But what happened was that I was the motion court judge on a particular day when a matter came before me as an urgent matter and the names were G.S. Gani and I.S. Gani or something like that. I was not asked to make any decisions in that matter. It didn't occur to me that this might have been a client of mine. There are many Ganis in Durban, and I made no connection on one level or another. I was not asked to make a decision. They were both represented by senior counsel, or at least one was by senior counsel. One might not have been by senior counsel, but by a senior advocate. And a consent order was given to me, which I then made an order by consent. So I wasn't asked to make a judicial finding or determination one way or another. I was simply asked to record an agreed consent order and adjourn the matter. If I had known that he was my client previously, if someone had told me that, I would have, even in the face of a consent order, I would have said to them, are you comfortable with me making this consent order? I would have said to both parties.
Yes. But I mean, the point is, it's not really the nature of the order. The real answer is, well, I'd forgotten if he had been a client. Because if he had been a client, the duty would have arisen anyway.
Maybe. And I say maybe, Commissioner, because as an advocate, the independence of advocates allows you to represent a party in one way on one day and in another way on another day, as long as the matters aren't related, as I understand it.
Yes,
but you're right about one thing. I didn't know. If I'd known that they were parties, I would have certainly investigated whether there was a reason through a connection between the two matters why I should not be involved.
Yes. Well, sometimes, you ask a small question and then it gets bigger because of the answers. I thought this was a small question, so I would really like us to close it. The fact is you were not aware that this was your ex-client.
No.
You're not making any arguments about whether there was a duty of disclosure.
No.
Yes, all right, thank you.
Thank you.
Commissioner Trollip?
Thank you, Chief Justice. Advocate Pittman, just for the record, and I'll be using the record later, was your late father Christopher Pittman's brother?
Yes.
Okay.
My late father was Harry Pittman.
Okay.
Christopher Pittman was always known by all of us as Kit.
Kit, right. When I read the papers, your application, your questionnaire, listened to the JP talking about your virtues, and I read your responses to the complaints. I found it very difficult to reconcile even the people that had nominated you, where one of them said that you were generous and honest to the core. I found it very difficult to reconcile the allegations that were made by the complainants, and you did respond comprehensively. What do you think the genesis of those complaints were? Were they malicious? Or?
Are you talking about the demolition, the AFT complaint? Are you talking about the complaints that AFT raised in there? Right. Well, what do I think are the genesis? It's a very difficult question to answer because I really actually have no idea.
You have to speculate now.
I beg your pardon, CJ? I'm sorry?
Do you want to speculate?
No, I don't really want to speculate.
Then maybe we should not waste time doing that. You don't know.
I have no idea.
Yeah.
But what I can say is that as an advocate, what I've realized as a judge since I've been acting, and lots of people don't really get this. Our system of justice is an inquisitorial system of justice, not an acquisitorial system of justice. In other words, there are two teams that compete against each other in court, and a judge is a referee. Just like you get your referees in football matches, and you get your referees in rugby matches. And unfortunately, the way our inquisitorial system works is that there's often a loser. And when you are a referee, sometimes you simply get blamed. It can happen, I've seen it happen. I don't know, I'm not speculating about this case, but it is a possibility.
Have you finished, Commissioner Trolley?
Thank you, Chief Judge.
Do we have questions from the virtual platform?
Yes, Chief Justice.
Please put your questions, Prof.
Good evening, Advocate Pittman.
Good evening, Commissioner.
I think the story that you have narrated is commendable. The one that you spoke about trying to assist advocates from unfortunate circumstances for them to be able to afford their chambers. And I just want to build on that. We have learned, at least today, that there are still very much challenges with respect to the briefing patterns in KwaZulu-Natal, and the black females in particular seems to be, or they are definitely at the floor of the briefing line. What role, if any, have you played in ensuring that, at least in your practice, because you are not the one giving out work, you cannot blame you for giving out work. In your own practice, what role have you played in ensuring that at least you rope in some of those people from difficult circumstances for them to be able to at least get some head start in their practices? Thank you, CJ.
Thank you, Commissioner. The nursery chambers is one way that we have I've managed to cut down costs so that they can make ends meet. As I refer to in my application somewhere, and it pains me to have to repeat it, I paid for a particular advocate's chambers for 3 months because they were not being paid by the state attorney. I have an open door policy. Every junior in my group trails in and out of my chambers all day, every day, because I'm trying to help. I use the juniors from previously disadvantaged circumstances, particularly those that I am aware of who are battling financially, because I administer the group of advocates I work in, and I'm aware of the financial difficulties some of them are faced with because they come and tell me. I use them to devil for me and pay them from the fee I get from the attorney. Those are the kinds of things that I am involved in to try and ameliorate the difficulties that struggling juniors are faced with on a daily basis.
That is commendable. When you do rope them in, do you rely on them in terms of the work that needs to be done? Because there is also that part of the transformation in making sure that they learn in the process.
Yes, most definitely.
No, thank you very much, CJ.
Thank you.
Thank you, Prof. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Advocate Pittman.
Good afternoon, Commissioner.
I just want to follow up on your answer to the question from Professor Marumahai. Did you bring any juniors into your matters as juniors, not as devils?
Yes, I have. But I'm very rarely briefed on the basis that I'm entitled to bring in a junior. So on the occasions that I have, I've paid for it out of my pocket. What I can tell you, though, is that as a judge, I've had a much better opportunity to provide not only the imparting of skills, but some financial relief to previously disadvantaged people in respect of the criminal work that I do. Our criminal procedure provides for assessors. I'm very comfortable doing criminal work. I could do a case without an assessor, but the purpose of assessors is important. One, because by its very nature, it allows for the input of a multicultural approach, so to speak, if you use assessors who are not necessarily lawyers or who are lawyers but are from different cultures. But the second thing is, I have so far done criminal sessions where I've used two assessors. I approached the bar for struggling black women who would be able to get experience in a full-blown criminal trial that they might not get anywhere else, and at the same time earn the assessor's fee. Those who I've used. And if I use assessors in the future, those who are the people that I'm going to use.
Advocate Pittman, my question was about juniors that you work with and not assessors that
Yes.
you helped get appointed. Do I understand your answer to be that your practice didn't permit you to bring juniors onto your matters?
No, sometimes, no. Ordinarily, what happens is an attorney will brief me to do something. I will say, can I bring a junior in to help me? They'll say, no, we haven't got fees for that. I then have still brought juniors in, but then I pay for that myself, which I've done. But it's not always possible. And the assessors that I use are juniors. I use juniors as assessors.
I think let's leave the question of assessors aside. I'm interested in the fact that you indicate that not all of your matters are worthy of bringing in juniors. It's not sufficiently big to bring in juniors.
Now, my practice is very big, but the nature of the case will demand whether the attorney will permit you to bring in a junior. And the nature of the client that the attorney has will decide whether the attorney gives you an instruction to bring in a junior. As counsel, you act on instructions from attorneys. You don't tell an attorney that his client must pay for a junior. You can advise it, and I often do. But that's how the relationship between attorneys and advocates work, as you probably know.
I'm slightly familiar with the concept.
Yes.
Only slightly.
So there are cases where I think I need a junior, and if the attorney won't give me one, I use one of the juniors and pay myself. There are other cases which do not require a junior, and then I won't have a junior.
You see, Advocate Pittman, you've portrayed yourself as a proponent for transformation, but you've indicated now that your matters didn't always require the use of a junior.
Yes.
I just want to then get onto the second issue, which is your conscientious objection to taking silk, or to applying for silk, rather.
Yes, all right.
Has it ever occurred to you that you may be able to bring in more juniors if you apply for silk?
All right. It's not a conscientious objection to taking silk. And I'm going to refer to my family background again. I grew up in a family which held that status and title was irrelevant to the qualities of a human being. Now, that had an effect on my personality. So I started as an advocate, and up until this point in time, I feel personally fulfilled in what I'm doing. I haven't felt the need to apply for silk. Yes, your question is a very good one. If I take silk, I may very well then be limiting myself to the kinds of cases where a junior will be necessary. And in view of the development of the institution of silk, more specifically recently, with solid criteria being laid out for how you get there, I am thinking about that. If I don't get the job as a judge, that's probably the route that I will take.
Thank you, Chief Justice.
Do you have questions, Commissioner Bredenbach? Commissioner Mangen?
Thank you, Chief Justice.
Yes?
I don't have any, thank you.
Oh, thank you. I thought we'd lost you. Commissioner Mangen?
I'm covered, CJ.
All right. All right. You are excused with thanks, Mr.
Thank you very much.
Pittman. We
Thank
have
you very much,
finished the
CJ.
interview.
Thank you, Commissioner.
Recording in progress.
Is the Premier here, JB?
He is here, but he just stepped outside. Mintu? I'll ask the Secretariat to just nudge him.
Okay. Just bear with us a little while, Ms. Singh. There he is. Good evening, Ms. Singh.
Good evening, CJ.
We must apologize for having kept you for so long, but these things happen.
It's all part of the course, I suppose,
Yes,
CJ.
we are sorry. I know it's not a pleasant experience. You hail from Devon.
That is correct, CJ.
And you obtained your legal qualifications there.
I did, CJ, yes.
A BSOCSI from the University of Natal.
That is correct, as it then was known, yes.
Yes. And then you did your LLB at the University of Devon, Westville.
Also, as it then was known, CJ.
Yeah. You spent some time, well, a brief spell at the Lawyers for Human Rights directly thereafter.
No, CJ, I actually didn't. In my CV, I mentioned that I did some work for Lawyers for Human Rights, briefed by them, but not.
Oh, all right. Okay. It's a bit misleading. But then in 1996, you joined the KwaZulu-Natal Society of Advocates.
That is so after completing my pupillage, yes, CJ.
All right. I assume that you do, well, never mind what I assumed, it's irrelevant. So you joined the bar in 1996 and you've practiced as an advocate to date?
That is correct, CJ.
That's 28 years?
Going on to 28 years,
almost
yes.
28 years, yes. What kind of practice have you conducted in this almost 30 years?
CJ, coming straight from university, when I commenced practice, I was willing to take on matters to give me courtroom experience. So I started doing criminal matters, legal aid matters. I did high court pro deo cases. I was then fortunate to have been able to join Advocates Group 7. And there were many senior, junior advocates who passed on work to me, bearing in mind that I didn't know any attorneys to brief me when I started practice. So these pass-on briefs helped me forge relationships with attorneys, do the work to the best of my ability, and thereafter I was in turn able to obtain or be briefed by these attorneys. My practice started with a lot of matrimonial and family law work. It then moved on to doing matters in the areas of law, succession, trusts. As I became more senior, I developed a trial practice with matrimonial work, with personal injury matters. Yes, so that's been more or less my practice, CJ. A very broad-based practice, if I may describe it as that.
You also mentioned insolvency and property law matters in your...
Some insolvency and some property law matters, yes.
All right. You mentioned that you've also lectured to paralegals at the Community Rural Development Center.
Yes, I did, CJ. I did for a brief period of time. It was on a voluntary basis where I would go on weekends and lecture to paralegals, more in the area of family law, maintenance matters. There was also a time when there were problems with applications for social grant matters, and paralegals would needed advice and to be trained on how to go into the community and assist the community with those types of issues.
Yes. You've acted as a judge intermittently between 2004 and now.
Yes, I
Last
have.
stint having been in May? May,
Uh,
yeah, May.
Yes, CJ, I acted in 2004. I did a criminal session in Pietermaritzburg High Court, a criminal session. Thereafter, I began acting in 2023 again. As at the time I completed my application, I had acted until 31 May, but subsequent to that, I have done 2 further sessions, one criminal session and one civil session. So all in all, CJ, I've got about 43 weeks of acting.
23?
43.
43, oh,
Yes.
all right. And you've written judgments during this acting stance?
I have, CJ, yes. On a
About how
rough
many?
tally, about 35 written judgments, excluding extemporary judgments.
All right. Have any of those judgments been reported?
No, they've been published, CJ.
Okay. Any judgments reported in matters in which you participate as counsel?
Yes, and I think I've made mention of it in my application, CJ.
It's late in the day, my spirits are flagging, so you'll forgive me if I'm slow.
Certainly, CJ.
Well, if I feel like that, it must be worse for you. All right, I'm going to hand over to JP Boyodward.
Thank
to
you,
question
CJ.
you.
Thank you, CJ. Good evening, Advocate Singh.
Good evening, JP.
I think you might get a benefit because it's late in the day, and try to be short because I am tired. By this time, almost all courts in the country have adjourned.
Yes, yes. JP.
How were your acting stints?
JP, I enjoyed all my acting stints tremendously. Initially, where I had doubt, I was thrown into the deep end in the January-February session last year of motion court in Durban on a busy Monday morning, and it was then that I realized that all the years of practical experience came to assist me. And I must say, where I did encounter any difficulties, I must thank the KZN division, because every single sitting judge was more than, including you, JP, were more than willing to assist me with any queries I had. So it's been smooth all in all.
And compared to the one you had in 2004, how, I don't want you to criticize it, obviously. I just want to see the atmosphere, because in 2004, we were still lagging behind in terms of diversity, maybe.
Yes, JP, in 2004, we didn't have our morning teas and our judges' lunches, which we now have, and which we now have the opportunity to discuss matters of relevance. I know there's the introduction during our Thursday judges' lunch, where one of the senior judges will discuss areas of interest or matters of concern in the division. In fact, there were no teas and lunches in 2004.
Yes. And I must commend you for hard work.
Thank you, JP.
I've sat with you on appeals, full bench and full court. In most instances, particularly where I sat with you, and obviously I benefited, you had prepared a draft for most of the matters that we sat in.
Well, Judge President, there may be something to be said about the more the merrier, because I adopted the attitude in my acting stints, the more I did, the more beneficial in terms of experience for me.
Yes. And I recall when you started acting, you almost had a conflict with some court staff because of the Lekedia style that they do things relaxed, and you wanted things sharp. And I had to remind you that this is government, not private practice, and it might be taken in another way, but not to allow them to be like that, but just for you to understand.
Yes, JP, I'm actually very grateful for that lesson, because apart from just getting the experience of acting as a judge,
there are many life experiences that one learns. Having come from private practice, maybe I was used to doing things in my style, if I may put it that way, and I've had to learn to deal with diverse personalities being on the bench. So yes, I'm grateful, and I've definitely learned something from that.
And you have embraced our diversity to the extent that I think they have given you a clean name. What is it?
I'm a Hadebe.
Yes.
And I proudly accept it too.
Yes. The fee dispute committee that you are involved in, obviously that allows you to, well, makes you to know how to make unpopular decisions. But how does it work and what type of things that you adjudicate?
Generally, JP, it's in terms of the GCB and Society of Advocates rules, and our power is very limited to determining the reasonableness of council's fees. As a committee, we do not involve ourselves in other disputes which may arise, but really it's the reasonableness of council's fees.
Yes. And have you mentioned
where I've become more senior, and certain briefs do not require that level of seniority, I very readily refer my attorneys to counsel who are junior, but it goes a little more than just referring the attorneys to counsel who are more junior. I actively then check up on these juniors if they have drafts of pleadings. I check up on that. I actively assist them in preparing for court where necessary.
Yes. And the reserve judgments, what is the longest that you have reserved a judgment for?
I think it would be 5 or 6 weeks, JP. I've had reserve judgments from 1 day, where I've reserved it for a day, or otherwise 5 or 6 weeks, but not longer than that.
Yes, and I remember that at the beginning of one of the sessions, you were given a very huge matter, but you did not squeal, but just dealt with the matter.
Yes, JP, that was an opposed motion where it involved almost 9 opposed applications, and it was set down for 2 days. I'm happy to say I finished it within 1 day, and I delivered my judgment within 3 weeks.
Yes, and how many volumes was it?
9 volumes.
Yes.
Yes.
And you've conferred with colleagues when you had doubt on any issue.
Yes, and that is why I'm so grateful to the sitting judges of our division who have always readily assisted me.
Yes. And maybe finally, what are the greatest attributes that you will bring to the bench?
Firstly, I would say, JP, it would be my years of practical experience. I've got a very good work ethic. I'm not somebody to rest until I've gotten something done. So yes, it would be my very good work ethic. I'm a person of integrity. I'm also a very collegial person. I find it very easy to get along with people. And if I may say this, JP, I was part of one group of advocates for 18 years. And we have different personalities, but until we dissolved, for various reasons, people moving out to other buildings, I was part of that group for 18 years. Presently, I'm part of the group of Advocates Group 7 for 2 years, and before that, I was a member of Advocates Group 7 for 5 years. So I generally get on well with people, and I think that would contribute to our division working in a more united way.
Thank you, CJ. That will be all from me.
Thank you, JP.
Thank you, JP. Premier?
Thank you, CJ. I must say I'm impressed with the energy that Advocate Singh has at this time of the day.
Thank you, Premier. I think it is years of hard work and working till late in the evening that has kept my spirits up over the years.
Yeah, no, it's just one question. What's your view on the delayed judgments, and what do you think could be your contribution when you are offered the position to turn around as such, where you will be actually be employed?
Thank you, Premier, for the question. Delayed judgments, unless they are unduly delayed, sometimes it is understandable, the pressures of work for judges in our division. I know it's a very busy division, but it's also not excusable. There really has to be a cut-off time, because part of the reason, and I know this from years of being in practice, people come to court wanting their day in court, but also wanting finality on their matters. As to what I can do to lessen reserve judgments is, as I get more senior, I'd be willing to offer advice to more junior judges, to acting judges, almost like how the bar has been for years, an open door policy. So that would be what I would be able to offer.
Thank you, Chief Justice.
Thank you, Premier. Do we have questions from the virtual platform?
Thank you very much, CJ. I do have one question. Good evening, Advocate.
Good evening, Commissioner.
I see in your questionnaire that your practice at least is constituted about 25% of family law and divorce law. Is this something that you are quite familiar with?
Family law and divorce law, yes, I've practiced a fair amount of it.
All right. I have a question. Currently in practice, there's a serious problem, and I just want to get your thoughts on it. We see more and more members of pension funds resigning from their pension funds before a divorce can be granted. And we see more and more of these decisions coming in. I'm not sure, one, are you aware of this issue that is currently going on in practice? And how do you think this issue can be resolved to ensure that the other spouses are not prejudiced in terms of the claims that they may have on the pension fund of the member of the pension fund?
Thank you for the question, Commissioner. I think that is a very difficult one to say, because one finds that in matrimonial matters, parties sometimes become bitter and antagonistic towards one another, and unfortunately, the only way for this type of issue to be resolved is for spouses to be familiar with one another's financial affairs, and should there be divorce proceedings, the spouse who is a non-member must perhaps take all steps to timeously advise his or her attorney that they suspect that there will be a resignation, and then the necessary steps in terms of court proceedings must be brought for this.
Let me this is not something that you have came across in practice, right?
I have come across it. Yes, Commissioner, I have. Generally, it was approached on the basis that an interdict is sought against the pension fund, obviously with the member of the pension fund being cited as a respondent.
Oh, okay. No, Chief Justice, let me leave it there. Thank you very much.
Thank you, Commissioner.
Thank you, Prof. It does not. Oh, there is another hand. Commissioner Elikhanyan.
Thanks very much, CJ. Good afternoon, Advocate Singh.
Good afternoon, Commissioner.
I want to start by saying that we cannot confidently say that we have achieved with regard to the affirmation of women in this country, particularly in the judiciary and other sectors. If you were to be appointed, what becomes your commitment to lifting up the spirit and supporting other women, particularly those who belong to previously marginalized communities?
Should I be appointed, then I am aware that the Office of the Chief Justice, or SAJE, runs various mentoring programs, various training programs, such as the Aspirant Judges Program. If I am called upon, and if in any way I can assist in that sort of training, then I will be more than willing to do so, Commissioner. Thank you.
There are no further questions for you, Ms. Singh. Thank you very much for making yourself available.
Thank
for
you,
this
Chief
vacancy.
Justice. Thank you, and
wish
thank you to
all
all
the
the commissioners.
best.
Thank you.
You're excused.
Thank you.
May I ask non-JS members to clear the room so that we may deliberate?